Good morning. I'm Steve Barney. I'm Chairman of the Civil Service Commission. To my far right is Vincent Llewellyn, Vice Chair and member of the Commission. And sitting between us is Judge Ed Sweeney, who is a retired judge in St. Louis, but also for some years has been a hearing officer for the Civil Service Commission. The first order of business is to act on the proposed changes to the rules to accommodate this unique hearing. And I'm going to move adoption of those pending any motions during the hearing regarding these modified rules. So, is there a second?
I second.
Just a minute. Okay.
The motion, though, I'm just trying to understand the protocol that's just being adopted here today on the day of the hearing. When do I get to make my motion?
During the hearing.
What point during the hearing? Before you adopt them or afterwards?
After we adopt them, we'll still accept comments on
Well,
them.
but how can we adopt rules that we have objections to without hearing our objections? How does that work? I'm just trying to understand the process,
Well,
because I'm new to this.
Everybody's
everybody's new to this.
Well, I'm saying, but when I go to court, I've been throughout this courthouse, that courthouse, 38 years, 40 years of practice, and I've never walked up in a courtroom where I didn't know the rules. So I'm just trying to find out the process, the protocols, that apparently, are they written in those rules in terms of the fact that I have to wait to object until you vote to accept these rules? Is that the process here today, Mr. Chairman?
Well, we had said that when these rules were modified in order to accommodate the unique circumstances of this hearing, and I think you were notified of those rule proposals, that we would act on them at the front of the hearing. So
No. I was not notified of that. I was not. What I was notified of, and we can get the emails from the record, I received a copy, what was it, last Monday, of an email from Mr. Marvin, Michael Garvin, counsel, which I understand is counsel for the commission, advising us that here's some rules that may possibly be applied in this hearing. He didn't say that on Tuesday, a day after the scheduled hearing, that you all were going to vote on these rules without us having an opportunity to weigh in, without having the public an opportunity to weigh in on the propriety of these rules, whether or not these rules are fair, whether or not these rules provide due process of law to my client.
All right, Mr. Norwood.
May I, Your Honor, with all due respect, with all due respect, sir, I am talking to the commission.
You are not, I know you're talking to the commission, and they have asked me to serve as a hearing officer to actually run the hearing, and at this point, you are interrupting business between two commissioners that you have no standing to do.
No standing, Your Honor.
When we start,
Your Honor, no standing?
When we start a hearing, you will get the opportunity to argue certain things as the commissioners deem appropriate at that time. But right now, you are out of order.
I thought we started the hearing, Your Honor. I thought we were on the record.
We have started the commission meeting.
Oh,
The commission meeting is what the chairman just called to order.
okay,
A meeting of the commission.
okay,
They called the roll.
okay.
And the next thing he did was make a motion to accept Mr. Garvin's written proposed excerpts from the rules. Now, when you say what rules we have, of course, city charter, ordinances, rules that commissions have in the past. Those are the rules. If
Okay.
anything is not in those rules, then that's something that the commission has to decide what we do, and if you have an objection, you've got to make it at the time.
Well, and I'm making it at the time.
No.
I'm making it right now,
No.
Your Honor.
Okay,
Right.
why don't we do this?
Well, can I say this? Can I say this, Your Honor? Can I say this? Can I appear here as a tax-paying citizen in the city of St. Louis who's paid taxes on income I made here for the year, who our firm is based down here and done so much. Can I talk here as a taxpayer? I'm going to take off my hat.
No, Mr. Norwood.
Oh,
No, Mr.
taxpayers
Norwood.
can't weigh in on rule
No,
changes,
not-
sir?
Taxpayers cannot show up at any city board or commission meeting and just interrupt and start talking. If
Okay.
there's an appropriate time for
Okay.
public comment at a meeting, then that would be the time.
Well, what is the appropriate time for the
You're
public
going to
comment
get a
today?
time, as you well know, as the attorney representing the party, when we start this hearing. So not now.
No, but he
So
just
sit down.
said, he just
Mr.
said,
Norwood, you are out of order.
Sir,
Sit down.
a point of
And
order.
let the commission proceed.
Can I get a point of order, Your Honor?
I haven't even called the roll for this meeting.
I understand, but I'm trying to understand these
You
new
are not,
rules.
you are not someone who can make a point of order in a commission meeting. The members of the commission are the people who could raise a point of order. There's
But-
only two commissioners here, and neither one of them has raised a point
I
of order.
understand, I
You
understand.
are out of order. You need to sit down.
I am sir,
You need to
sir,
sit down, Mr.
with all
Norwood.
due respect, sir.
No, Mr.
This is
Norwood,
what I'm trying to
at
get
this point,
I'm
you
trying to get
are-
clarification.
You-
Clarification for my client who's here today to be terminated by the mayor.
Mr.
May I
Norwood.
ask one question, and then
No.
I'll sit down? May I ask one question?
Oh.
Then I'll sit down. He just said
May he?
that
I would like to call the roll to start the meeting.
but, excuse me, Mr. Chair, with all due respect, you just said that I would have
He just
an
said, no, you
opportunity.
may not ask a question, so
Okay.
you may just sit down.
Thank you.
Okay, thank you, Mr.
Thank you.
Norwood. Thank you, Mr.
Where's
Norwood.
the camera? Thank you.
You may sit down, Mr. Norwood.
Thank you.
Before we act on the motion, would you call the roll, please? For-
Chairperson Barney,
Here.
Vice Chair Llewellyn.
Here.
Now, the motion before us is to adopt the amended,
We have a quorum because
oh yeah, we have a quorum, so we are in session. And the motion is to adopt the modified rules, subject to any motion or discussion during the hearing regarding those modified rules. Is there a second?
I second.
Any discussion? Do you want to make any comments or anything?
No.
All right, would the clerk call the roll, please?
Chairperson Barney,
Yes.
Vice Chair Llewellyn,
Yes.
motion passed.
And at this point, we have asked our hearing officer to conduct what will be the formal part of the hearing pertaining to charges about the Director of Personnel.
All right. And with that, thank you. We'll proceed. The first thing we will do is take up the motions that have been filed by the Director, Ms. Jenkins Gray. They have sent a communication which lists motions or written oppositions, which they said they wish to take up today. And some of those motions they had previously submitted in writing. Others they included with their motion, as they note, including motions not previously submitted. Now, the commission, the two commissioners, have met, and they have discussed some of these motions, and those motions, the commission has decided that they can rule on based on the written submissions by the parties. Those include the motion to disqualify or quash an investigation by the mayor's office. The commission has overruled that. That has the commission doesn't have any authority to quash or disqualify the mayor from making or doing any investigation. The city charter gives the mayor the right as the executive officer of the city to take certain actions as the executive officer, and the commission feels that any motion here to disqualify or quash something by the mayor regarding the investigation is not a matter properly before this commission. So that motion is denied. The motion to disqualify the city councilor has been considered and denied. The city councilor's office again, by the city charter, represents the city in all matters. And unlike private law firms, ethical rules on disqualification of a lawyer when another lawyer in the same law firm it might have a conflict of interest, that is not applicable here. There's a long history of city councilors' representation and advice to various city agencies, and the written writings submitted do not raise anything that would change that. So the commission has voted to deny that motion. The motion to deny or disqualify the commission from hearing the case because there are only 2 commissioners instead of 3 because there's a vacancy. Again, that has been considered based on the submissions, and that is denied. The 2 members of the commission make up a quorum, and there's nothing in the charter that says that the commission cannot proceed here just because there's a vacancy. So that one is denied. The motion to strike the city's motion to quash a subpoena directed to a records custodian for the city, that motion is moot because no subpoena was issued by the commission for a keeper of records. So that motion is moot. The motion to strike the opposing counsel's motion to quash the subpoenas for the mayor and so forth, we will hear that motion when we get to the hearing on the evidence in the case. Next one that was considered based on what was submitted in writing was the motion to preclude the use of a hearing officer. Again, the commission has considered that and has ruled that that motion is denied because the provisions cited by Ms. Gray's attorney argue that the commission, the charter requires the commission to conduct the hearing. The commission is conducting the hearing. They have simply asked me to assist, and in that way, they are still conducting the hearing. Anything I do here today is subject to approval by the commission. And so that motion to preclude the use of a hearing officer is denied. The motion to continue the matter after rulings on the motions to allow for a judicial ruling, in other words, to recess the hearing before taking any evidence in order for parties to take this to court and have a court rule on the motions, that is denied based on the written submissions. And there's nothing cited in the written submissions that would raise a question that would cause there to give any cause, a just cause for that motion to be granted. With that, I'll go back. There were a couple of motions that I skipped over. One of them is the one Mr. Norwood has been talking about, which is the rules. We'll get to that in just a moment. Another is to exclude any evidence of any violation not specifically contained in the notice of the hearing. And again, based on the written submissions, the commission will just simply take that motion with the case, but more importantly, that motion is really in the nature of a motion in limine, trying to prevent questions about certain matters. That would have to be taken up whenever and if a question is asked a witness that is asking for some matter that the motion, by what it's contains would suggest would somehow be irrelevant or not proper to bring up here. So you'll have to make that objection at the time, and we'd have to make a ruling on the objection at that time. All right? And that also applies to the motion to exclude testimony related to personal family matters. That is something that if a question, we don't even know if a question is going to be asked of a witness about anything like that, but if there is, that would be the time to make that objection. So those will be taken with the case. The motion, I'm sorry about that, the motion to quash the city's document subpoena, that is something that we can take with the case, I believe. And the motion in opposition to the city's motion to quash, what we talked about the city's motion to quash is, I think, quash subpoenas by the mayor. That is, I think, the same one as the motion to strike opposing counsel's motion to quash subpoenas, the same subject matter. So we will hear that. I think that covers all of them. There is one more, I think, that I didn't mention. Motion for continuance based on a defective notice / new evidence / non-response to subpoenas. And that motion for continuance, again, for a continuance, the commission has considered that and denied that based on the written submissions. With that, we'll go, Mr. Norwood, and you've been very patient. We appreciate it. But you have indicated that with regard to rules, you did receive a copy of some the way it's titled, I believe the page is Civil Service Commission Evidentiary Process for Hearings Conducted Pursuant to Article 18, Section 9Q of the City Charter. Am I correct, Mr. Norwood, that's the thing?
I have no idea. Can I have a copy of?
Well, I thought you said you did get a copy.
I received a copy of something.
From Mr. Garvin.
I need to
Well,
know.
do you have
I
your
need to
copy
see
with
it.
you?
I don't have it with me. I want to see what was approved today. Can I make a copy? Can we make a copy?
Well, I believe that this is what the commission approved today.
Well, and I'd like a copy. Can I
This
have
is a copy.
Okay.
So I guess we can
If I
mark
may.
this as the commission's copy. You'll please return this,
Yeah,
right?
and I just, can we have the director of personnel make a copy without being accused of spending improper money to make the copy? Can I get that on the record?
So you did not even bring the copy that you received so that you could compare it and see if it's the same one?
I wanted to get a copy of what was voted on in this meeting.
All right, we do have a copy, so
Okay.
let me just mark that, we'll keep that, and here's a copy of it, same thing,
Thank you,
right?
thank you.
So, now, with that, the question would be, you have had an opportunity to review that, correct?
I don't know, I need to take the time and look at it.
No, when I said that, I meant what you were sent by Mr. Garvin at December 30th, I believe it was.
Whatever
More
that
than a
was.
month ago.
No, it wasn't a month ago, it was a week ago.
All right. You did receive it, though.
A week ago, I received something.
What?
I don't know if it's
what-
this one or not.
Fine. What in it are your objections? In other words, what in there is something that you say is a rule that somehow violates your client's due process? Your
Well-
motion says that you are raising this motion to protect your client's due process rights. So what are, one by one, what are the things that you are saying are not proper?
With all due respect, Judge, I would like to address the rulings on the other motions, on this record, if I may.
All right, if you want to make a record on the previous motions, the rulings that were made, go ahead.
Thank you,
Make your
Your Honor.
record.
Thank you.
It's 18 minutes after 10.
Okay, and I left my watch at home. Your Honor, members of this commission, I'm appalled. I'm appalled And I'm going to start with something we talked about off the record that should be on the record. I came in here, my team couldn't get in the garage yesterday, couldn't get out of their garages yesterday because of a record snowstorm that has blanketed the city. Blanketed. We had a notice that said we were going to have a hearing yesterday. God, for whatever reason, canceled the meeting. And you all canceled the meeting because nobody was here. So we haven't had proper notice of anything today. Nothing. Number one. Number two, I explained because of the weather, because of Uber, my client couldn't get here in time for a hearing that we just found out about this morning. In fact, I can read into the record. Mr. Harris sent an email. Let's get this in this record, okay? Mr. Harris sent an email. Bear with me. I know the clock is running, but just bear with me. 7:03, email from Mr. Harris to Mr. Garvin and to me. Are we starting at 9 o'clock? And that's at 7:03. He didn't know what time the hearing was starting, right? So my client, who yesterday was advised that the courtrooms wouldn't open until 10 o'clock, somehow, and they've been through a lot in those courthouses. I've been in a lot of those courthouses. If they can't operate until 10 o'clock, I query why do we have this urgency to start at 10 o'clock and then off the record saying, well, we'll see what happens at 10 o'clock. Number one. Oh, that's number two, I'm sorry. Commissioner Flewellen, your comment off the record in this hearing room, when we got lots of witnesses and some of them may appear in that courthouse down the hall, for you to say in front of these people, when I'm explaining to you the fact that she called an Uber to get here, to be here, and to say in such a flippant way, well, I took an Uber and I prepared. What kind of justice is that? What kind of fairness is that? You tell me, Mr. Commissioner, tell me what kind of, to make a comment like that in a public venue like that is abhorrent. With a capital abhorrent. And yet her future, her livelihood, her career rests in the hands of you. I want to understand the process here, because let's talk about the motions. There was a denial. Let me pull it out here so I'm not misstating the record. And we got an email from Mr. Garvin this morning. I can tell you that was after that 7:03 email, saying, oh, by the way, the commission wants you to bring copies of your motions. So my team, we're scrambling downtown, digging out of their garages, trying to get to the office to make copies of those motions that you've already ruled on. So we wasted some paper, scrambling, copying, wasted billable time that my client's paying for to get the copies, and we come here denied. Denied! Without giving me a chance to even weigh in. Your Honor, you've been around the block several times, as have I. Is that due process? I'm just asking for the record. Is that the kind of due process that my client is entitled to under this system? What kind of system is it when we don't get proper notice? When we get rules dropped in our laps the morning of? When you looking at the clock saying, well, if she's not here by 10, tough, Uber be darned. What kind of process is that? We're on the record. We're here for city taxpayers, and this is what our taxpayers are paying for. This is the kind of system that my client is being subjugated to. On the motion to disqualify, the commission, on this record, I want to know who was in the room when that motion was being made and who voted. The commission voted not to disqualify itself. Is that what we're to understand here today? Mr. Chairman, is that what we're to
That's
understand here
correct.
today?
That is correct.
I'm sorry, I'm talking to Mr. Chairman.
No, Mr. Norwood,
I can't
that's
talk to the
correct.
chairman?
You actually can't
Your
ask
Honor.
questions. You actually can't ask questions.
Why not?
What you can do
Why not? Where
is
does it say in
make
this rule?
make
Say
your
Ron Norwood can't ask questions. Where is that in these rules?
make your record.
Is that in the rule?
Make your record.
Sir, I'm asking for a point of order. Where does it say I can't ask a question
Mr.
of the
Norwood,
commissioner
Mr.
who is
Norwood.
presiding over this matter?
Make your record as to what you're objecting to.
I
Don't-
am
you don't get to
asking
cross-examine the
the
commissioner.
I'm not cross-examining. I'm asking for procedural clarity. For the record.
All right. What is your question of the
The
commissioner
question is
about
who
procedure?
was in the room when you all voted to deny the motion to disqualify the commission?
We were all here.
We who? The public and everybody else?
We did that a few
two
minutes back ago.
But who was in here?
The two members of the commission.
And who else?
And the hearing officer,
And here, and who else?
Mr. Garber.
Mr. Garvin.
Okay, and who else?
That was it?
That was it, okay. Was it a public hearing? Was it a closed hearing? What was it?
It was not a hearing.
What was it? You voted to approve some rules.
It
What
was-
was it?
It was a meeting of the commissioners, a conference.
It was a meeting.
Uh,
Was it at a public conference or a private
It
conference?
was a meeting of the commissioners.
Sir,
to-
with all due respect,
to
I'm
consider
talking
the
to,
motions
I'm
that you have
talking
made.
to the commissioner, the chair. Can I address
And
the chair?
The commissioners have asked me to run the meeting, and I'm answering your question.
He was
He's
answering my
answered it.
question, and then you cut him off.
You
I'm
got,
I answered it.
you got your answer.
and that's what I'm trying to figure
Your
out.
your question was who was there. You got your answer.
Okay, question number one. Number two, who voted at that meeting on the motion to disqualify the commission?
The two commissioners.
Commissioners.
The two commissioners, okay? And I take it the hearing officer didn't vote. He wasn't the third.
Hearing officer has no vote.
Oh, okay, great. I learned that. Is that in here too? I didn't see that. But, okay. So, and then we had an alternative request. The alternative request was to disqualify Commissioner Barney. Okay? Who voted on that one? Did you vote on that one, Commissioner Barney, to not disqualify
The two
yourself?
commissioners, to save time, Mr. Norwood.
Yes.
The two commissioners voted on everything.
Okay.
All I did was, as the commissioners asked me to do, go through and give the results of what the commissioners had voted
Okay.
on those various
Okay.
motions.
Okay, all right.
So you know what the rulings of the two commissioners were.
Okay, and I want to know, my client wants to know, I think the public wants to know. So, just so the record's clear, Mr. Barney, Commissioner Barney, I'm sorry, voted to deny my request to disqualify him to be a fair and impartial determinator of her life when, in a public hearing that I attended on Zoom, you outed her. You called out the fact in a public meeting that there were charges pending against the director. Which then, well, actually, we got evidence of this. We deposed Dr. Anthony Berg last week. He testified, and we're going to offer that testimony, that when he sort of heard you reference the director, he said, time out, time out. First of all, it's not on the agenda. Why are we talking about charges against the director when it wasn't even on the agenda? And then, this is his sworn testimony. This is not Ronnie. This is your secretary. Said, when I attempted to intercede, I was rebuffed. And not only that, he didn't only say he was rebuffed, he said, this is your secretary, that, oh, well, it was already out there anyway, so what? And that, excuse me, let me finish.
If I may.
Let me finish.
This is out of order. The commission has
First,
already.
just for the record, identify yourself.
Yeah.
Yeah, I'm Reggie Harris, representing the appointing authority in this matter.
You have an objection that this is out of order.
Yes, because the commission has already ruled on the motions that he's trying to re-argue, and he's engaging in a colloquy with the commissioners. None of that is proper. I would ask that the commission direct Mr. Norwood to get back to the motions that the commission would like to hear so that we can move on with the process.
I'm going to sustain that objection, Mr. Norwood. You are trying to re-argue the motions the commission has ruled on.
Well, I never argued them in the first instance, so how can I re-argue
We
something I've
understand
never
that you
argued?
submitted the motions in writing with your reasoning in your motions as to why they should be granted. The commissioners considered what you submitted and denied them based on your submission. That's the end of it.
No,
Mr.
it's
Harris
not,
is
Your Honor.
correct.
No, it's not.
Yes.
It's not the end of it.
You're-
I have
it's
a
the end of it.
constitutional right on behalf of my client to argue motions before this commission.
It's-
And I don't see anything in the rule that says I cannot.
It is your constitutional right that you can appeal what this commission does to the courts at some point. Whenever you do that, if we do anything that violates your client's rights, that, of course, would be something that you could take up then. We hope we do not do anything that violates your client's constitutional rights. We realize that, like any dispute between parties, people might have different opinions, and you are making your argument as to why you are saying you think something is wrong here. The
Sir.
commission has disagreed with it. You submitted it in writing. It's been overruled. Mr. Harris's objection is sustained. Please confine yourself to making a record now on what your objections are to the procedure
I
that
am-
we're following.
With all
The
due
city
respect.
charter sets out the fact that the director has this right to a public hearing. The director is here in person.
Yeah.
And got here in person by however she got here, by Uber, as you've said. We did not start the meeting until she got here. And you have wasted time talking about all of that. There's no right of your client that was denied. She's here. So please, quit wasting time, quit filibustering, and just argue your motion to exclude the use of modified rules as violative of due process. All you have to do is tell us what is there in here that you are objecting to as a violation of your client's due process.
Your Honor, with all
So the commission can consider that.
With all due respect, Your Honor, I've appeared before Your Honor multiple times.
Yes, you have.
And every time I filed a motion with you and any other court I've ever been into in 36 years of practice, I have had an opportunity to argue a motion, to supplement the writing, to elaborate. You, Mr. Hearing Officer, Your Honor, saying I'm wasting time? This is a waste of time? This is a waste of time. It is a waste of time and waste of money. $170.30. Okay, that's the elephant in the room. Let's bring that elephant and plop him down
No, Mr.
right in the
Barhead,
middle of this
We'll
courtrum.
get to the evidence in the hearing
I
at the
am
proper
not,
time.
sir, I am not going to be constrained.
is
And
your-
if the effort here is to muzzle me, you got the wrong lawyer. Okay? I am going to advocate for my client's rights because the charter, since we're talking charter, let's talk charter.
Yes. Yes.
The charter says in no uncertain terms that my client has a right to present a defense. How can I present a defense with a muzzle on? With a stopwatch? When the rules don't say anything about a stopwatch? How is that fair? I'm trying to get fundamental fairness. That's all I want. That's all I ever wanted in any courtroom in the land. And you're telling me that I can't weigh in after the fact on the denial of motions which seeks to disqualify the commission, which seeks to disqualify Commissioner Barney, which seek to, with all due respect, disqualify you, Your Honor, from even serving as a hearing officer.
I don't think it was directed at me personally.
No,
I
no,
think
not
it
you
was
personally, because at the
directed
time I
at
wrote it,
the use
I
of
didn't even
any,
know who it was.
the use of any hearing officer, I
yes, I'm
believe was
sorry.
your motion.
Any hearing
officer.
Any hearing officer.
Your Honor, I have another objection and a suggestion. The commissioners have the authority to manage this matter, this hearing, and that's in the rules that the commission has just adopted. Mr. Norwood clearly wants to talk about these motions that the commission has already denied, and for whatever reason does not want to get to the evidence so that he can put on his defense. My suggestion would be that we proceed with the evidence, after which Mr. Norwood can revisit these motions that have already been denied.
And where in the rules or the charter does it say that, Mr. Harris?
Once again, in
Where? No,
in
because I'm
those
just trying to
rules.
clarity. I don't swim in these waters. Tell me where it says that. Tell
in
me
the
where in the
rules.
All right,
charter it says that.
Mr. Norwood, Mr. Harris, Mr. Norwood, Mr. Harris's point is that you are not directing your remarks at what you have repeatedly been asked to do, which is to say what rules we have, and you have a copy in writing, and there's nothing in here that is really violates anything that I see in
Okay.
the city charter
Okay.
or the civil service rules.
Okay.
But if you're saying that something in here violates your client's due process right, direct your argument what violates your client's due process right in
Okay.
these rules.
All right.
So that the commission
Okay. All
can
right.
consider that and then make a ruling on it
Fair
if it
enough.
thinks you're right or wrong.
Fair enough. Okay, I'll take this temporary muzzle for now. All right, let's talk about these rules, right? What violates my client's right to due process? This violates my client's right to due process. The inability to argue on behalf of her reputation, on behalf of her career, on behalf of her family, on behalf of her husband, and more importantly, on behalf of the civil servants of the city of St. Louis, because that's what this is really about. Tony Messenger hit it on the head. This is a power play. It's a power play. So if we're talking about the rules, this violates my due process. I can't argue, and I don't see anything in the rule that says Ronnie can't argue motions that have already been denied by a commission to who I'm seeking to disqualify. Where is that in the rule?
Mr. Harris,
No.
Mr. Harris pointed out that it is common sense and long time practice.
Common
that
sense,
the
Your Honor? Is that
commissioners-
what that's the law now, common
that the
sense?
commissioners have
Common
the right
sense.
to manage
Common
a
sense.
hearing. Any hearing has a hearing officer. In a court, it's a judge. Here, it's the commissioners, and the commissioners have asked me to serve as the hearing officer. Any hearing to proceed in an orderly fashion has to have someone who can manage it. Now, that is what I am doing on behalf of the commissioners, and that management includes telling you what has been done. We went through those motions and told you which ones were ruled on based on what you submitted, and then now managed it in the sense of we're on one particular motion. Your motion to preclude the adoption of new modified rules as violative of due process. Now, you have a copy of what was adopted. What
Can I
in
read
there?
it?
What in there?
Can I read it?
If you want to take a moment to look
Yeah, can we
through
take
it,
a
because
recess?
you already got one.
I got
You've mentioned
something.
a week
I need to
ago.
make sure it's the same copy.
Presumably, you've reviewed that.
I did.
So when
In fact,
you
I
look
have a
at
red
this
line
one,
of I
it
have
should
a red
be
line.
things that ring a bell.
Well, may we take a recess?
Take a
while
quick
I review
5
this?
minutes.
5 minutes, thank you.
Well,
If anybody needs-
I would ask that we not go in recess. I would ask that while he's reviewing this copy, if I could address this matter as well.
Thank you, Your Honor.
Mr. Norwood, Mr. Harris wants to address it. Do you want to listen to him or not?
Well, I don't know what to address until I see what we're addressing, if I may.
Well, I'm going to permit him, since I permitted you to make your argument, I'm going to permit him to make his argument. He's asked to address the same topic that you just talked on.
Well, I haven't addressed it
I'm
yet.
going to permit that.
I haven't
So
addressed
let
it
him
yet.
talk. You're there, you can listen, you can hear it. I was trying to keep you from going out where you'd miss it.
But-
I don't
but-
want you to miss it.
But I
Go ahead,
haven't
Mr.
addressed
Harris.
it yet. I
Go
haven't
ahead,
seen it
Mr.
yet.
Harris.
I
Mr.
haven't
Norwood,
read it yet.
I know,
But
called
I
on
thought
Mr.
I had
Harris.
the mic.
Mr. Harris?
Are you taking the mic, Your Honor, and giving it to Mr. Harris in
You
the middle of
stepped
my
away
miking?
from it. You stepped away from it. He stepped up to it, and then you stepped up and
Oh.
elbowed him out of the way.
So I have to make sure I sleep with the mic. Is that what we're saying here? You all
I-
said I had an
would
opportunity to
suggest
address it.
you don't step over when your adversary is actually at the podium, at the microphone,
I had
and
the
start
mic.
talking when he has the floor.
I had
So,
the
Mr.
mic.
Harris, go ahead.
Wait a minute, I'm not, okay.
Step away, Mr. Norwood.
Honor,
Mr. Norwood.
you gave me the
you
mic.
mentioned your many
You
years,
gave me
30
the mic,
plus years.
38,
You do
40.
not have it.
But who's
Step
counting?
away.
No, sir. Listen, I am
Step
going to.
away, Mr. Norwood.
I
You
will
are the,
not. I will not. And
You are
here's
being
why.
extremely discourteous.
I'm not being discourteous, Your Honor.
Yes,
I
you
am
are.
fighting for a civil service system that's under attack by the mayor.
You are.
And if I have to
being-
go to jail to do it, where are the marshals? Take me to jail for simply advocating for my client, for advocating for the civil service system, for advocating for you all.
Nobody has suggested that, Mr. Norwood. You're raising all these accusations.
I'm not raising
Nobody has
accusations.
mentioned putting you in jail.
Well, I mean, I can't talk, and I need to talk. I had the mic, and when I wanted to step out of the room to review the rules that you all adopted today, I lose the mic.
You are continuing your discourtesies. Let Mr.
I
Harris
am
make
not-
his point.
I am
Mr.
not. I
Harris,
haven't made my point.
Mr.
Can I make
Harris,
my points?
go ahead.
Can I make my points first?
No. Mr. Harris, you may proceed.
I just wanted to make a record that these rules that have been discussed for, seems like forever now, they are modified rules from the rules that have been in place since even the previous personnel director. And I would anticipate that the current director is familiar with those rules since she is the secretary of the commission in her role as personnel director. So those rules have been in place for years. And the modified version of those rules were sent to both parties, I think on the 30th of this month, giving each party the opportunity, if it wished, to point out what in those rules are problematic.
Point of
And within-
clarification.
and
Excuse
within
me,
that-
it was the 30th of last month. I'm just
Right, yeah, the 30th of December, sorry.
That's right.
The 30th of December, to point out what portions of those modified rules are problematic, make their case, and get it resolved. That has not happened, at least not from the personnel director and her counsel. Again, we have seen these proposed modified rules. We've had them for over a week now, and have been able to discuss, either with each other or with the commission, what the concerns are, and that has not happened. So I think that, given the clear attempts here to prolong and delay the hearing of evidence in this case, that this issue should be put to bed. The motion, whatever it is, should be denied. The rules have already been adopted so that we can move on to the evidence in the case, to understand why we're here, as opposed to the filibustering to keep the public and the commission from hearing the underlying facts and circumstances of this matter.
So,
Do you agree?
Mr. Commissioner,
I'm asking the commissioners and they both are in agreement that Mr. Harris's point is sustained. His objection in effect to you filibustering. Now,
filibustering, sir, I'm
Mi-
offended.
Mr.
you're talking about
Norwood, you
courtesies?
made a request
Courtesies?
that we
You're
take
accusing
a
me of
5-minute
filibustering?
break to let you look at that document, and I
Okay.
said I would grant that.
Okay.
I'm going to, Mr. Harris, as far as a recess, anybody that wants to use the restroom or anything like that, we're not going to do anything. It's now 10:44. We'll wait till 10:49, Mr. Norwood, for you to read it over, then come back, and then you can tell us what, if any, objections you have based on violations of your client's due process rights.
Thank you.
You're welcome.
Appreciate
Judge, may I
it.
approach real quick?
Okay,
Not to-
not on the record?
On the record?
On the record, go ahead.
Thank you very much. Thank you very much. My name's Sam Alton. I'm representing a peripheral witness in this case. Her name is Ashley Jenkins. Mr. Harris has very thoughtfully said that we'll work something out with her. She is a disabled veteran who has a meeting with the Veterans Administration at noon. My understanding is that one way or another, she's not going to be she's not going to be needed today. I'm not conceding that she's subject to the subpoena, because if you look at the subpoena that she was sent, it's clearly for civil service employees, and she is not one. But I'm not going to make much noise about that argument right now. I just didn't want anything to happen this afternoon, and then we're not here, and people are wondering where my client is. We'll come back, work something out with Mr. Harris if necessary, but that's what I believe is going to happen with her today. Is that accurate?
Yeah, I mean, I believe, it's my understanding that, as Mr. Alton has said, she has an appointment at 12 o'clock. We don't want to keep her from her appointment. Given what we've seen thus far, I do have some concerns as to whether or not we will be able to complete this hearing today. I'm an optimist, and I hope that we can, but I have my doubts about that. And to that extent, I think it's highly likely that we will not get to
Ms. Jenkins.
today.
I just respect the
She
process.
certainly can go to her meeting. Is she, her appointment after that, is she going to be in touch with you where, if needed, she could be back?
She is. Today is going to be difficult because the meeting with respect to her disability or whatever occurring, she doesn't know how long it's going to take.
Sure.
But we're in constant communication, and I'll work with Mr. Norwood and Mr. Harris to make sure, if necessary, we find a way to bring her back here
All right.
if the time comes.
Thank you, Mr. Alden.
Thank you very much.
All right, Mr. Norwood, you had a right to hear that too, so it's 10:46 now. You've got till 10:51. So, Mr. Norwood, you again are back at the microphone. You've had a chance to look at the document. Is it the same one, as far as you can tell, that you received December 30th?
It appears to be. yes.
Okay. Now, what, if anything, in that document, which is headed Civil Service Commission Evidentiary Process for Hearings Conducted Pursuant to Article 18, Section 9Q of the City Charter, what in there are you objecting to as violative of your client's due process rights?
Okay, I got a litany of concerns. Let's call it that. First of all, my chief concern is the authority of a commission that should be disqualified from even weighing in on this thing, meeting in a room with a hearing officer who's not on the commission to discuss the rules. You have a lawyer, but I don't see anything in here that gives the honorable the right to be in there deliberating with the commission, right? I mean, because the charter says that the commission shall consist of 3 members. And he stated on the record, he's not here on the record, he's saying you all are conducting the hearing. He's just here. So we have a problem with that, fundamentally a problem with anyone who comments about, I took an Uber, I could do it, I'm sure she could do it, when we didn't even get notice of a time until 7 a.m. this morning, right? I have a problem with that. Maybe it's me. I don't know. I have a problem with that. I mean, maybe I'm hypersensitive, okay? I have a problem with that. I have a problem with not really knowing what the rules are coming into this thing. That's like playing a football game. Imagine we're in the Final Four of the college football game, and we're all pumped up, and we go in there and say, oh, the rules have changed. Right? The field goal is now 50 yards. The goalpost is now 10 feet wide. That's what I'm confronted with that. And I've been in the game a long time. I spent 2 years in federal district court in Kansas City, working for a fine federal judge, Judge Scott O'Wright. And you may know Judge Wright, may he rest in peace. Okay? I've seen everything. I would say that commercial, I've seen a thing or two. I've seen it all. But I have never, ever seen anything what I would describe humbly and respectfully as farcical. Farcical. So that's fundamentally our main problem. I have a problem fundamentally with the notice. To the extent that these evidentiary rules, in violation of the city charter, which says there has to be 10 days notice provided to my client, I have a fundamental problem when we're knee-deep in snow, when the city's shut down, and get a note from your lawyer saying, oh, we ain't going forward tomorrow. This is Sunday. I got a call. We're working, preparing. We ain't going for it. The city's closed. Okay, bet. Then what due process says and what the rules require and what the charter requires is, okay, no sweat. Send out a new notice so that the public, who knows who's stuck in a garage right now, can't get here. Right now. I see some hands. May I have a witness out there? Okay, quite a few. Right? Couldn't get here. I got witnesses who are stuck in their garage. Can't get. Instead of doing the honorable thing and saying, okay, fine. God, for whatever reason, decided to blanket our wonderful city with snow, our wonderful region throughout the country. Instead of doing the honorable thing and said, okay, we'll send out a new notice, we'll set a new hearing. No, we gotta go. The courthouses in this building didn't open until 10 o'clock. We get notice, and she got a notice saying the building's closed. So it's like, okay, fine, we'll start at 10 o'clock. No! And we had the stopwatch going. We'll see what happens at 10 o'clock. If she's not here, so what? That's what these processes apparently provide. That's the kind of due process, sewer process, that she's entitled to as a public employee, as a civil servant, as a 30-year HR person. That's what she's entitled to in this arena. And the beauty of it is the world can see it. But they say the revolution will be televised. Well, the castigation is being televised.
Let me just.
Okay, hold on. Can I? Hold on, Reggie.
Let me give my objection.
No, Mr. Harris.
This is
Mr.
all-
Harris, please. Mr. Harris, be seated.
Thank you.
This is all unresponsive.
However, I would caution the audience, this is not a pep rally. This is not a church meeting. This is not any kind of meeting where the audience is permitted to participate. So I'd ask the members of the public who are here, you have a right to be here at a public hearing to hear and observe. You do not have the right to cheer or cause any other improper or discourteous action. So please, members of the public that are here, and everyone for that matter, please try to conduct yourself as courteously as you always would. Now, Mr. Norwood, go ahead.
Your Honor, first of all, on behalf of the people who raised their hand, they weren't discourteous.
I
They were
did
just
not,
explaining-
Mr. Norwood, I did not say anybody in the audience who raised their hand or anything else. All I did was ask them to be courteous, all right?
Fair enough, Your Honor, fair enough.
Now, what, if anything, violates your client's due process rights? Your motion is very brief. it simply makes the motion to preclude the use of any modified rules not adopted prior to the public hearing as violative of the city charter.
Right.
All right?
Right.
And you have a copy of what Mr. Garvin had prepared, which he told the commissioners was what he could deduce from the city charter and other provisions of previous hearings and rules, what would be the way that this hearing should be conducted, and that's all he did in putting forth those rules. Now, what violates your client's due process rights?
Okay. Let me talk about article, Roman 18, section 2. Says, the purpose of this article is to provide a modern and comprehensive system of personnel administration for the city, whereby economy and effectiveness in personal services rendered to the city, and fairness, and equity. This is not Ron Norwood. These are some citizens way back when, may they all rest in peace, who found and determined that fairness and equity is the hallmark of civil service, the hallmark of the commission, fairness and equity. And I'm telling you, what I have experienced here today falls woefully short of fairness and equity, in my humble opinion. The charter provides that to the extent, and of course, as someone mentioned, it may have been you, Your Honor, historic, never been done. First time. Nobody has had the cojones. No one has had the chutzpah. No one has had the unmitigated gall to seek to remove a director of personnel. Nobody in the history of the city. Yet here we are for $170.30. In fact, let's talk about that. Let's get it on the record, okay? For this, where's the comptroller? This is what this case is about. $130.70.
Mr. Norwood,
Yes.
what the case is about, evidence in the case, that
This is-
was what we'll get to when we start hearing evidence.
I thought we were talking due
Not
process.
now.
Due process.
The question
Due process.
was, what
I call
in
due
these
process.
rules
I call due process.
violates, you what?
I call due process.
Okay, great.
That's what-
We all believe in due process, I hope, as citizens of the United States.
I hope.
The question, Mr. Norwood, which you have not even remotely tried to answer,
Oh,
is
remotely.
you were
Wait a minute,
given
may I- may I,
a
Your
copy
Honor?
of these
I just read
rules.
the charter. How is that not remote?
You
How is
were
that not
given a
remote?
copy of the rules, and you were asked, what is there
But,
in those
sir,
rules that you are contending violates your client's right to due process? Please,
But,
tell
sir-
us what, if anything, in the rules violates your client's right to due process.
Sir, with all due respect,
I
fact that
appreciate the due
the
respect.
fact that you can say on this record in front of these citizens, in front of these cameras, that what I'm saying is not remotely relevant causes me to question where we are in this process, because everybody's witnessing it. They saw me read the section from the charter. How is that not remotely connected to due process? Your Honor,
I'm asking you, what in the rules, and if, Mr. Norwood, I believe it is at least the sixth time, if not the seventh time or more, that I've asked you, and you don't give us an answer, we will simply proceed
I'm giving
without
you an answer.
any-
They don't
further.
like the answer, but
Your
I'm giving you an
motion
answer.
is to exclude adoption
Yeah.
of these rules because you contend they violate your client's right to due process. What is it in there violates your client's right to due process?
Okay, where was I? The fact-
Where you were was not answering the question.
Well, I beg to
Answer the
differ.
question.
I beg to differ.
What,
Because what I said.
what in these
what I
rules
said,
violates your client's right to due
the
process?
fact that disqualified commissioners are adopting rules on the day of the hearing that were provided to us the Monday before last.
Where is that in these rules?
Where's what in these rules?
You said something about the two commissioners adopting rulings the day of the hearing. Where is that in the rules?
Well, I don't see it either.
Okay.
So what allows the commission? What allows the commission to adopt these rules the day
It is
of?
not pertinent then to your motion
It's
because
due process.
because your motion is that these rules somehow violate your client's right to due process.
They do.
Tell me what in the rules. You
Well-
just talked about motions that were adopted this morning. There's nothing in the rules about the commissioners adopting motions this morning. So you're not talking about an objection to the rules. Now,
I
Mr.
am.
Norwood, last time.
I am, sir.
Answer the question.
The absence of guidance on that point is a violation of our due process rights. It's
Okay.
like going to that football game and getting rules and non-rules and on the fly, Your Honor, and you know, and we know, just between us, we know this is not due process. We've been in this game a long time. We've handled dozens and dozens of cases. We know what due process is, and we know this ain't it. So yes, we're talking about due process.
Okay.
Okay? The rules purport to allow you, honorable, distinguished jurists, to serve as a hearing officer when the charter provision addressing the removal of the director is unequivocal. Shall means shall. We know that, Judge. We've litigated that issue tons of times. And it says the proceedings shall be conducted by the commission. And when they say commission, they don't say 2 out of 3. They don't say anything in the charter I've seen that allows for a quorum of 2. What if you all get tied up? What do? We have a do-over then? You want to do the right thing and let her go? You want to maybe do something different and not? What do we do then? What does a commission do then? We'll have to reconvene, have another hearing, and keep having hearings until we get the seat filled with a third commissioner. That's what the charter requires, and that's why it says the commission shall consist of 3 members, and we don't have 3 members. That's a problem. It says it shall be conducted by the commission, and it's not being, we got witnesses. I don't see the commission conducting. I see an honorable, distinguished judge conducting the meeting. That's what I see.
Thank you.
Maybe I'm, seeing things, but I see.
No, you're seeing correctly
I
there.
see an active, wonderful jurist conducting this meeting in violation of the city charter. That's what I see. And I think a lot of other people, they can't comment on it, but I think they see the same thing because we're all looking through the same lens. We're trying to look through the lens of the charter, which says fairness and equity. We have a problem with section, let's get specific, process, Roman numeral 3. A, it says the hearings shall be, another shall be conducted in accordance with the applicable provisions set forth in Chapter 536 RESMO. That's the Missouri Administrative Procedures Act. And I've litigated a lot of administrative procedures, and I've never been shut down. I've been denied a lot of motions, but they give me the courtesy of, I think the judge called it, filibustering, because I'm paid to filibuster. That's what I do. I'm a filibusterer. If you want to call advocating for my client, if you want to call advocating for the bailiffs, if you want me advocating for every civil servant, I see one driving now, these snow sweepers. If you want to call me advocating for her rights and their rights as filibuster, guilty as charged. Put the cuffs on, lead me down to the jail.
I did not call that filibuster.
Well, I think the record speaks for itself.
It will. It will.
Okay. So, Yes, I'm gonna filibuster, if that's filibustering. If getting paid to represent my client is filibustering. If trying to get equity in a system designed for equity is filibustering, yeah, I'm a filibuster. Just call me Mr. Filibuster.
Well, perhaps I should have used the words, not answering the question.
Okay, fair
Same
enough.
meaning in the context. My contention is you're not answering the specific question you were asked. So, Mr. Norwood, you've pointed out Chapter 536. Are you contending that that part of the rule somehow violates your client's due process rights?
Absolute. I'm contending that to the extent these processes, I don't know anything. Let's look at the administrative APA. I don't know of any rule that allows a commission on the day of the matter.
No,
Without-
Mr.
no,
Norwood,
you
Mr.
ask- can I
Norwood.
answer your question?
I'm
Can I answer the
asking
question?
you, what your motion is to not allow the adoption of these rules because they violate your context due process rights. That's your motion. Now,
I'm
you
amplifying.
cited
I'm
the
already
fact that
amplifying.
in Roman numeral 3, section A, under process, it says the hearing is conducted according to Chapter 536.
Yes, yes.
Are you contending that that provision of the rule somehow violates your client's due process rights?
I am contending that this process, if we want to call it that, violates every facet of the Missouri Administrative Procedure Act, which has been entered in accordance with due process, to
Okay.
provide a right to fairness, to provide a right to notice, to provide a right to a tribunal untainted. We can agree with that, Your Honor. Can we agree that an untainted tribunal is the hallmark of due process? Let's go to Roman 3, process D. It says, all motions shall be on the record and submitted with the record. Check, we did that. And then it says that the following motions may be filed by any party to the appeal. Well, I don't think we're appealing anything unless somehow the mayor's got a written resignation order in her desk. We ain't appealing nothing. We're here today to represent her, to represent the commission, to represent you all. So these rules as adopted don't apply because we're not dealing with an appeal.
All right, what particular section are you citing there? You
Process.
You pointed us to process.
Roman 3,
Roman numeral 3 is
D.
process.
D.
D says
Yes.
all motions shall be on record and submitted with the record. We're doing that. The
Okay.
parties should not engage, should not, Mr. Norwood, and I
Yes.
think we got 13 motions by my count that you filed with the commission.
Yes.
Uh,
All denied.
No, they haven't all been
Oh.
denied yet, if you listened to what I said earlier.
Yes, my apologies, Your Honor.
Accepted. At any rate, all motions be on the record. Parties should not engage in extensive motion practice. And then it says, the following motions may be filed by any party to the appeal.
Okay.
Now, no, we are not here on an appeal, so obviously that particular line doesn't apply. All right?
Okay, so
So
it's
that
not-
just says what motions can be filed as a party to the appeal. That's not applicable. Then it says, other than specifically provided above, no other motions shall be filed. If other motions are filed, the hearing officer shall deny them. We've given you some latitude here in making these arguments. We, meaning collectively, the two commissioners who are running this, and me, who is managing it on their behalf, we have allowed you to make arguments on this motion that you filed, where you're claiming the rules violate due process. We have not yet heard anything in the actual rules that you are citing that violates your client's rights to due process.
Okay,
So is there anything else
Yeah.
in there? What else?
yeah. Well, the fact that I can't argue my other 12 motions, that's a problem. That to me, when we're talking about charter, when we're talking about fairness, when we're talking about equity, the fact that we're shut down in a secret room where you all decide, deny. Well, this one we might think about. Is that fair? Is that the process? Put yourself in this chair. Is that the process that you would want to have your careers, your livelihoods dependent on? The rule goes further, expressly, and says, it lists 6 motions. Motion for issuance of subpoena, motion to quash subpoena, motion for the issuance of additional subpoenas beyond the limit of 10 set forth in section 3G. I have a problem with the 10 limit, but okay. Motions to take depositions. Okay, we got one of those pending. Actually, we got one to approve a deposition that's already been taken, but that's another issue. Motion for continuance. I got 2 of those, right? I couldn't argue those. I like to argue those, but I've been muted. I've been muzzled by this commission. This fair and equitable commission has muzzled me, and I can't argue the myriad of reasons why we should continue it, including the defective notice. The charter provision that they're relying on says 10 days notice. We had no such notice. This is not a continuance. You can't continue something that never started to begin with. Yeah, we have problems with that. But it says, because that motion was denied. Okay, fine. There are some reasons in there too. The fact that we haven't gotten the documents, the fact that a witness is on a cruise somewhere who can't be here, and we deposed them last week, and then we get all these documents that we need to follow up on. We don't have him, we didn't have the documents, and so we're left here just nowhere. And we're saying continue the hearing so we can take these documents we just got on Sunday night, or I'm sorry, Sunday afternoon, 3 p.m., and I can't talk to him about it. That's due process. It says, quote, other than specifically provided above, no other motion shall be filed. If other motions are filed, the hearing officer shall deny them. Shall. That's due process, folks. That's the process that civil servants are relying upon as it relates to their leader. That's a problem, Your Honor. And if you were down the courthouse, the room in the city court, I know, based upon my years and years of experience with you, that you would find a problem with that. I think you would. Mr. Harris stepped up here, and it's in the record, so I'm not speaking out of school, everybody heard it. He said, we discussed these rules with the commissioners. I didn't discuss the rules with the commissioners.
I didn't.
That is not what I said.
That is exactly what
I did
said.
not.
Wrote it down.
Mr.
Well,
Norwood, the
I wrote it
record,
down.
Let me
Mr.
tell- let
Norwood,
me
the record will
clarify.
stand for
Let
itself,
me
but
clarify
The record will
what
stand.
happened.
Let's clarify.
but I'm going to let Mr. Harris object because you're now claiming that he said
Back
something.
the
in
record speaks for
Back
itself.
in-
It will.
September or October, so it was months ago, we sent the hearing rules that were already in place back under the previous personnel director to counsel for the current director and asked if he had any, problems, or if he wanted to discuss the rules as part of this process. Never heard from him. Never heard from him. So those rules, as I said before, have been in place for years. And as the secretary of the Civil Service Commission, I believe she knows that. Then, when Mr. Garvin submitted the proposed modified rules to deal with this particular situation, since there's not been a hearing for under this provision of the charter before, he sent some proposed modified rules again on December the 30th, and that gave us an opportunity once again to talk about what's problematic or what's not problematic, try to come to some agreement as to what those rules would be that we would proceed under. Not a word. Until today. Why? In order to delay this whole process. That's why. And I think, reasonable minds who are watching this understand that this is nothing more than a delay tactic. I think that at this point, the commission should put a stop to it, and at least as to this particular motion, and we can move on, or we can creep on at a snail's pace to the next order of business in this hearing.
If I may respond. What is the need for haste? Why will we have to rush through this process? Why? Is that fair and equitable under the charter? Why are we rushing? She didn't go down to Darlene's office and steal a bunch of money. She didn't bring a handgun in and shoot up the place. You know her. You all have worked with her shoulder to shoulder. You've seen her.
Mr. Norwood,
Can I finish, Your Honor?
No,
Can I
no,
finish?
no,
Can I
because-
finish?
No, you cannot finish because your argument is totally off the point.
It's
Now,
not on the point
Mr.
when we're talking
Harris's-
about fairness
Mr. Harris's
and equity.
objection to what you said was made, and the commission has heard enough on your motion.
I am not
Both of the
finished,
commissioners
Your Honor.
have
I've got
advised
a
me
couple more
that they
provisions.
believe that at this point,
Did they do it
your
telephonically? Because I didn't see them
failure-
advise you to do anything,
Your
Your
failure
Honor.
to
I didn't
point
see them
out,
advise you to
Mr.
do
Norwood,
anything.
there can only be one person talking, and you are not the person who's running the meeting.
I'm not
All right?
running. I'm
The
just- I'm on this
commissioners
side of the
are
court.
running it,
I'm over
and they
here.
are advising me, and I am managing it.
I
Now,
didn't see them advise.
I am managing it by telling you your motion is overruled. You can be seated. We'll be ready for the next order of business.
Your
the
Honor,
next order
Your
of
Honor,
business-
I'm going to make a larger protest.
You did.
I'd
You've
like
made
to
a
make-
record
I'd
here.
like to make an
No,
offer of
no,
proof.
this is-
I have a right to make an offer of proof. As you well know, the law.
This is not evidence, Mr. Norwood.
I'm-
An offer of proof is related to evidence.
And this is evident.
No, it isn't.
Yes, it is.
No, it
He
isn't.
just
We are not
swore
even
on
at the
record
evidence.
That he didn't say what he said.
Mr.
And we all
Norwood.
heard it.
Okay, Mr. Norwood, let's, both you and I, try to talk one person at a time.
Fair enough.
Because this is being recorded, and the recordings will have difficulty in getting what either one of us says. Now, your motion is overruled. We're moving on. Have a seat. The next
Your
order
Honor,
of business
Your Honor,
after the
Your Honor,
motion to
Your Honor, I have some more
preclude the
points.
adoption of new
Your
modified
Honor.
rules,
Hello,
which is denied,
I have-
according to the two commissioners who are sitting here.
to the non-presiding
Uh,
judge here, can I speak?
No. The
Okay.
next order of business is, I believe, your motion to exclude testimony related to family matters. I think I said, you have to bring that up at the time. All right?
Yes, sir.
I think I have covered everything that we've done. One last thing, you had a motion to make a continuance based on a defective hearing notice.
Yes.
I'm looking at the hearing notice of public hearing to be held on Monday, January 6th, 2025 at 9 a.m. This was posted, it says the hearing is open to the public. It has an agenda, and at the bottom, and the hearing, it says, will, among other things, item 3, deal with the pre-termination review and notice received by Director Sonia Jenkins Gray on Friday, August 23rd, 2024. And a copy of that was attached to this agenda, this hearing notice. And at the bottom, the last line of the hearing notice says, the hearing will continue on January 7th, 2025, if necessary. The commissioners feel that, obviously, everybody's aware of the snowstorm. The weather yesterday made it necessary to continue the hearing. We couldn't start the hearing because people couldn't get here, and everyone was notified, including you and your client, that we would be starting this morning by conversations, communications with Mr. Garvin, the attorney who's advising the commissioners on behalf of the city councilor's office. And so your objection that your client's due process rights are somehow violated by conducting the hearing today, January 7th, your motion is denied because the hearing notice clearly says, if necessary, and the weather made it necessary. And your client is here. She's here. And you talked about her problems getting here, and we waited for her to get here. So we didn't do anything until she got here. And we, I think, made a record of the time we started. It was right around 10 o'clock or a little after, and she was already here. All right? As you were. So there isn't any, there's no prejudice to your client
let me
about the meeting time.
May I tell you the
So it is purely a waste of time
May I talk
for
about
you
the
to have
prejudice?
talked about all those things, which tends to make Mr. Harris's point credible that all you are trying to do is delay this, drag things out so that we can't get to it. Now, your
May I
client
respond?
has a right to this hearing. Don't you want your client to get her fair hearing? Because that's what we're trying to get to.
Well, when does the fair hearing start? Because so far,
After
I
you
haven't
sit
seen
down.
I haven't seen it. Well, I have some point. Could I comment on the notice that you brought up to suggest that this complies with due process?
No,
To
you
suggest
made
that-
your argument
I haven't
about
made
the
my
de-
argument because you just pointed to a notice that I haven't even responded to.
No, you made a motion about a defective notice, and you made an oral argument here
Well,
referring
but
to a
you
notice,
justify
which
this
I
notice.
referred to, and it's overruled.
You justify this notice by saying the hearing will continue
And
on January
Mr.
7th. We haven't had a hearing to continue. And it doesn't say a time. What time on January 7th? What time? Isn't that required? We got public who has interest. They should know when the hearing's going to start. The civil servant should know when she's going to be presented before this commission. The notice doesn't satisfy that. Due process, the charter says 10 days notice. The rules, their rules, your rules say 10 days notice. We didn't agree to continue it, but here we are. So that's not due process. That doesn't comply with the notice. And to try to suggest that this somehow satisfies that, I don't think is accurate. There are people here stuck in snow who wanted to be here. Witnesses we have who wanted to be here. They couldn't be here because of the snow, not because Norwood called them up and said, psh, psh, don't come. No, they're snowed in.
Mr. Norwood, if we get to your case and you are presenting witnesses and you have a witness that you want to call, and otherwise the witness is a proper one to be called, and they have a problem stuck in snow or hit by a meteorite or whatever it is, bring it up at that time. You are premature. We haven't even got to the evidence yet, let alone your case. As you know, the appointing authority has to put on their case first. They have to make a prima facie showing that your client, Ms. Grace, should be removed before we even get to whether or not you need to put on a defense. I would think you'd want to get to that. But the ruling has been made. Please sit down, be courteous. The ruling's been made. You've made your record. We can proceed.
I have
All
not
right?
finished my record. Can I finish my record?
No. The next thing.
No, I just want to get that.
No.
No, Mr. Norwood.
You're limited
You can't,
to what is reasonable.
no,
And we
Mr.
think
Norwood,
we have given you
can't
far.
argue due process.
We think we have given you
No,
far.
Mr. Norwood, you can't advocate for your client. No, Mr. Norwood, you can't argue motions that we denied back room somewhere. No, Mr. Norwood, you can't speak out on behalf of these hardworking servants. No! The heck with the civil servants.
Thank you, Mr. Norwood.
Thank
The
you,
next
Your Honor.
item on the agenda is to proceed with the hearing. And so with the hearing, we'd ask for the city appointing authority to present its case. The appointing authority has the burden of proof in this case to prove that the director committed the violations of which she is accused which are set forth in that letter dated August 23rd, 2024. And specifically, those allegations are in paragraphs 2 and 3. Your dismissal is being considered because of malfeasance due to your actions on or about July 3, 2024. On that date, you have admitted to using a city vehicle for transport to Jefferson City on a personal matter in violation of Section 3.6 of the city's vehicle policy, which is publicly available on the city's website. The promulgation of a vehicle policy for the city is required under 3.54.060 within the city code, rules for the use of vehicles within the city code. In addition to use of the car, you also had a city employee accompany you throughout the day and beyond the hours of the normal workday. Paragraph 2, the city's code of conduct also states that appointing authorities are responsible for setting an example of competence and appropriate ethical behavior. And all city employees must meet acceptable standards of performance. The example set by the conduct described herein violates the city's code of conduct, and in so doing, included a subordinate employee, period. And that's the way it reads. I am reading it as it is written. Subsequently, you have blamed your subordinate for violating the city's vehicle policy in a troubling avoidance of accountability. Pursuant to Administrative Regulation 117, this conduct is a violation which is so serious that continued employment may pose a threat to the public confidence in and well-being of your department. And again, I read that because that's the charge. That is what Ms. Gray is accused of. That is what the appointing authority has to prove. And after they put on their evidence, Mr. Norwood, you on behalf of Ms. Gray get to put on any witnesses you want to call to try to show that that is not the case. The burden of proof here is, as in civil matters, by a preponderance of the evidence. So I think we are ready to proceed. Mr. Harris, are you ready to proceed?
Yes, Your Honor.
You may proceed.
Let me say first, we have some motions, a couple of motions to quash pending, and I assume we will take those up later.
That's correct.
Okay. Well, then, I would call Director Sonia Jenkins Gray to the stand.
All right. The witness stand is over there, Director. And I believe the clerk will administer the oath to you once you're over there. Is that right? Once you watch your step on the cords there, please. And she'll ask you to go ahead and get around the table there. Be careful. And now, if you just raise your right hand, face the clerk, she'll administer the oath to you.
Do you swear and affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. And if you, yes, please take your seat.
We're gonna pass out some binders of the exhibits that we plan to use for our evidence.
Okay?
You have the extra stuff?
Yeah.
Good morning, Director.
Good morning, Attorney Harris.
And just for the record, go ahead and state your name.
Sonia R. Jenkins Gray.
All right. And as you know, I am Reggie Harris. I'm representing the appointing authority in this matter. Good to meet you. We've already met previously.
That's fine.
And who's your employer?
The City of St. Louis.
What's your position?
Director of Personnel.
Can you just tell us briefly what are your duties and responsibilities in that position?
Sure, I have responsibility for the civil service system as it relates to hiring, terminations within the city, performance management, training and development, recruitment, and that's pretty much it.
And let me ask you, do you believe, you contend that you are qualified to be the Director of Personnel for the City of St. Louis?
I do.
Okay. Have you said, though, previously that you're not qualified for this position?
I have not said that I'm not qualified for this position. What I have said is that I believe that there are qualifications that require me from a standpoint of dealing with the things that I was faced with in coming into the city that have nothing to do with human resources.
Okay, so you're saying that previously you have said, though, you're not qualified, and as you have just clarified today, under those circumstances.
Objection, mischaracterizes the witness.
Yes.
All right, the objection is sustained in the sense that Mr. Harris, her answer stands as her answer. You can't paraphrase it.
Sure.
Right?
And so in that same, and let me just clarify. So I'm referring to a conversation that you had with Dr. Anthony Byrd. Is that right?
Yes, you are.
Okay. In that conversation where you said, you know, as you've explained, just in your testimony, you also said you're going to resign, right?
I said that I thought about resigning, yes.
Okay. All right. You said that a couple of times in that conversation.
Yes, I did.
Okay. And he's not the only person you've told that, right?
Yes, he is the only person that I've told that.
Okay. And this conversation that you had with Dr. Byrd, it was recorded, is that right?
Yes, it was.
You recorded it, didn't you?
Yes, I did,
Without his knowledge?
without his knowledge.
And is that something that you do on a regular basis?
No, it is not.
Okay, you don't record people in the personnel director's office on a regular basis?
On a regular basis. It's not a standard practice, but where I do sometimes need to record our meetings and different things like that, I do that.
But do you record conversations that you have with your subordinates from time to time?
Yes.
Without them knowing?
No, not on a regular basis, not without them knowing.
Let's say not on a regular basis.
Okay.
Have you done it before?
Yes, I have.
Okay. More than just the one instance we're talking about?
No, I have not.
That's the only time you've ever recorded a subordinate in the personnel director's office?
Yes.
Okay. Have you recorded conversations with peers, other directors?
No, I have not.
Okay.
Never.
All right. And is it a violation to record a subordinate without their knowledge?
No, it is
Jack,
not.
let me object. Calls for a a violation of what? Vague, ambiguous, calls for a legal conclusion? I'm waiting for a ruling.
All right. Well, Mr. Norwood, you'll get your ruling.
No, I was talking-
But I was
talking to
waiting,
Mr.
I was
Harris.
waiting for you to finish your objection.
I'm finished.
All right?
Thank you.
Your ruling is overruled, all right? The witness may answer the question if you understand it. Do you understand the question?
Please ask again.
Is it a violation of the Department of Personnel's policy to record your subordinates without their knowledge?
No, it is not.
So that's fine to do.
It does not violate any laws.
Okay, and it does not violate the policy within the department?
No. Not that I'm aware of.
Okay. All right. You received, did you not, a notice of pre-termination for the review of your conduct on July 3rd, 2024, is that right?
Yes, it is.
Okay. I want to just show you Exhibit 1, and I'll bring it up to you.
Thank you.
So I placed in front of you a binder of exhibits that some of which I will refer to during your testimony. Do you see where it says on the exhibit list that the first exhibit is that pre-termination notice?
Yes.
Okay. Can you turn to the first tab
Oh,
and just take a look at that?
okay.
Take a look at the pages after that too.
Oh, okay.
And is that the pre-termination notice you received?
Yes, it is.
Okay. And you received it on or about August 23rd, 2024?
Yes.
Well, I would just move for the admission of that document into evidence.
Any objection?
Yes, Your Honor.
On what basis?
Well, the notice purports to be a reliance upon Administrative Regulation 117, which doesn't apply. And he's acknowledged that. So to the extent that we're offering into evidence what purports to be a proper notice, we object to because it's not.
So I'm just asking.
Are the objections overruled? The exhibit number 1, as it's labeled in the binder, is admitted.
And the notice refers to an incident on July 3rd, 2024, is that right?
Yes, it does.
In which you took a trip to Jefferson City, Missouri that day with Dr. Bird.
That is correct.
And that you took that trip for personal reasons?
Yes.
Okay. I want to ask you about the details of that day, okay? So July 3rd, 2024 was a work day, is that right?
Yes, it was.
You were on duty,
Yes.
and Dr. Bird was on duty,
Yes.
and you were paid for that day?
Yes.
And what are your duty hours?
My duty hours are 24/7.
Okay, all right. Do you know what Dr. Bird's duty hours are?
Yes, I do.
What are they?
They're 24/7.
But does he have like official hours you need to
No,
be-
he does not.
Okay, they're 24/7.
Yes.
Okay, all right. And do you approve Dr. Bird's like time and payroll for his for him to get paid?
That has been delegated. I don't approve it directly myself.
Okay, who does that?
Bianca Lambert and sometimes Stephanie Green.
Okay, and Dr. Bird is a subordinate of yours, right?
Yes, he is.
What is his position?
His position is he serves as my chief administrative officer.
Okay, so he answers to you.
Yes, he does.
All right. Do you evaluate his performance?
Yes, I do.
Okay. Do you make decisions regarding, whether or not he gets a promotion and things like that?
Yes, I do.
Do you make decisions regarding his salary?
Yes, I do.
All right. Now, you don't answer to him, is that right?
No, I don't.
Right. He answers to you.
That's correct.
Okay. All right. So on July 3rd, 2024,
Yes.
you requested that he get a city vehicle, is that right?
No, I asked him a question whether it was okay.
Okay. So tell us more. You asked him what now?
I asked him a question if it was okay to reserve or get a city car on the morning of July 3rd.
Okay. And what was his response?
His response was yes.
Okay. And you asked him that because you at least considered that it was possibly not okay.
No, that is not accurate.
Why would you even ask him if it was okay if you didn't?
Because I don't reserve vehicles on a regular basis. I've never reserved a vehicle, and so therefore I asked the question whether or not it was okay.
So, but your question is whether or not it's okay, meaning can you do that, right? Or is it okay for us for you to reserve a vehicle?
I believe we have the text messages which can express specifically what was said.
Okay. All right. Well, let's show you the text messages. Because you communicated with him via text.
Yes.
All right.
Which exhibit, counsel?
So we're going to call this one because I don't think that one's include. Okay. Okay. So we have the exhibits that were marked in the deposition, but we can call them a new exhibit for this hearing.
I don't have a problem. Whatever you call them, you can have a copy of it.
Yeah, sure, sure. So this was Respondent's Exhibit 3 at the deposition of Dr. Bird. For the purposes of this hearing, we can call it Exhibit, let's just say 25.
All right, have you got it? Have you got it marked as Exhibit 25?
Yeah, we'll mark it as Exhibit 25.
Uh,
Oh, I'm sorry.
You do have some exhibits
I'm sorry, it is marked 6A.
6A in your binder.
Right.
Yes, thank you.
So that is what you're using.
No,
I'm-
no, it's not.
Okay, so,
It looks like
so
it's
we have
6C.
6A and 6C. Right now, we're dealing with 6C.
6C, okay?
6C.
That is which one now, because it's a little confusing here. 6C is in our binders, right?
That's correct.
And that's what you're referring to right now, and you better ask specifically about Exhibit 6C. Does the witness hadn't been asked about that yet.
Well, right, so
She may have been looking at it, but you need to
Yeah.
clarify that.
Right. So, Director Jenkins Gray, you referred to text messages, correct?
Yes,
And I want you to take a look at Exhibit 6C. Are those text messages that you're talking about?
yes,
Okay. And these are text messages that you and your lawyer provided during the deposition of Dr. Byrd, is that right?
I think so.
Okay. And you said that we can take a look at those messages to see kind of the conversation about
Yes.
the car, right? Okay. So take a look at the very first message in Exhibit 6C, and can you read that for us?
Morning, can you get me a car this morning? Call me, please. And that's why I wanted to see the text messages, because my original statement is now corrected based
Okay.
off of this. I knew that this was more accurate.
Got it. So that's you asking him to get a car?
Yes.
Okay. And then he answers, good morning, and then he says yes. Is that right?
Correct,
And he is Dr. Byrd.
correct,
And then there's a message after that that says, is it okay to drive it to Jeff City?
correct,
All right. And then he says yes. Is that right?
correct, yes.
Then he says, would you be back today or after 5 p.m.? And how do you respond?
I responded by saying, can you go with me?
And then what did you say after that?
I said, after 5.
Okay. And then if you look at the next page, it continues. So after you say after 5, what do you say next?
I said, maybe I'll get a rental car.
Okay. And then what's his response?
Yeah, what time do you want to leave?
Okay. And you say 10,
Yes,
right? Meaning you want to leave at 10.
yes,
And then you say after that, I'm going to get a rental car.
correct,
And then you say, it's not completely city business.
correct,
He says, that's fine. You say, call me.
right,
Okay, and in the text messages that you provided, after that, he says, I reserved the car.
correct.
Did he call you when you asked him to call you?
No.
He did not call you.
No, I'm sorry. Yes, he did call.
Okay.
Yes, he did call.
And what did you talk about in that conversation?
He said that he was going to be, let me see, he said call me, but I think he called me after he said that I reserved the car. No, I can't say for sure when it was that I talked with him in the midst of the text messages, but during our conversation, I asked him, I said, can you reserve a black car?
Okay. All right. You said can you reserve a black car?
Yes.
Why did you want a black car?
Just my preference. I drive black cars. No special reason.
Okay.
I own 2 of them.
Okay. So I want to, we'll get back to 6C, but take a look at 6A.
Okay.
And you recall these are text messages that Dr. Byrd provided, which we went over at his deposition. Is
That's
that right?
correct.
Okay. And it has, the same conversation that you were just referring to, right?
Well, let me object. I mean, are we going to move to admit this, or what are you going to do, counsel?
Well, there's no objection right now. He can either ask to admit it or not. He hasn't done that yet.
But he's
That doesn't
talking
mean he
about-
can't do it.
He's talking about a document that hasn't been admitted into evidence.
Well, I think he's got to get her to identify it first. but
Well, she's testified that those are the text
that
messages.
Exhibit A was also?
Right. Text messages.
Perhaps
that-
I didn't
that
hear
doc-
that.
I missed it too.
Ms. Jenkins-Gray, you've had a chance to look at A, and you're familiar with that? Looks like the same
It looks, yes.
conversations as
Yes.
you've already talked about in C, right?
Yes.
All right.
And those are the text messages, again, that were presented by Dr. Byrd at his deposition.
Yes.
All right, so I would move for the admission of Exhibits 6A and 6C.
No objection.
All right, they're both admitted.
Okay. Now, so I want to direct you to look at the second page of 6A.
Okay.
You see that?
Yes.
Okay. We talked about how you said you wanted him to come at 10. I'm going to get a rental car. He says that's fine, right? You said call me, and he said I reserved the car. And then there's a message after that, furniture rescheduled, and you say okay, or
Attorney Harris, which page? are you
same
on?
page, second page.
Okay, second page, okay.
You see where it says furniture rescheduled?
Yes.
And then after that, it says okay. And then the very next text says, sadly, all the cars are marked. Is that right?
Yes.
Now, that's not in the text messages that you and your lawyer provided, right?
No, it's not.
Okay. Why does he tell you that all the cars are marked?
I don't know. I can't answer for Dr. Byrd. I just know that the only thing that I talked to Dr. Byrd about was getting a black car.
So, okay, so what you're testifying to is
Yes.
you asked him for a black car
Yes.
because you like driving black cars.
Because I like driving black cars.
His
yes.
response was, sadly, all the cars are marked.
That is correct.
And you don't know why he said that.
I don't know why, because in his deposition, he stated that I asked for a black car.
And you were sitting right there in his deposition, weren't you?
Yes, I
The
was.
whole time.
Yes, sir.
Okay. And in response to his sadly all the cars are marked, you say no worries, right? You say okay. Then
Anytime between 12
then
and 12:15.
he says, do I need professional attire or jeans? And you say jeans, right? You say I have on sweats.
Yes.
Okay.
I would like to also note for the record, Attorney Harris.
Yes.
That in the text messages that Dr. Byrd provided, the text message that stated that this was not completely for company business is missing.
Right.
Yes.
Right. So yeah, thank you for that. So
Yes.
so Dr. Byrd provided some text messages, some of which didn't include text messages that you provided.
That's correct.
And you provided some text messages, some of which didn't include text messages he provided.
That is correct. That's
Okay.
what it appears. Yes.
All right. So both of you are submitting text messages, but you're leaving stuff out.
No, I submitted, no,
Let me object that mischaracterized the testimony.
yes.
No, that's a question, Mr. Norwood. Your objection's overruled.
Thank you.
Did you, Mr. Gray, did you understand his question?
Please ask the question again.
So both of you are providing text messages, but you're leaving some of the messages out.
No, I provided text messages that I had. I did not leave anything out.
Okay, but you remember we read where he said, sadly, all cars are marked, and you say no worries, right?
But I'm telling you that the text messages that I submitted are text messages that I had.
But that little exchange wasn't in your text messages that you submitted.
You would have to ask Dr. Byrd how he came up with that, because I did not.
Are-
I only submitted what I had to submit.
You said how he came up with that?
I don't know. I can't answer to that.
Are you suggesting that he he slid some text messages in there?
I'm not suggesting anything. I'm just saying that what I submitted is what I had.
Okay, got it. So you asked him to drive you to Jefferson City,
Yes.
and you asked Dr. Byrd because you at least considered that maybe, I mean, you asked him if it was okay, right?
Yes.
Because you consider that maybe it's not okay.
No, that's not
Okay.
it. Because if you go back to the first text messages, I didn't ask him if it was okay at that particular time. I just said, "Can you get a car?"
Okay. And then you said you were going to get a rental because it's not completely city business.
Correct.
Okay. All right. You said jeans were fine and that you were going to wear you were wearing sweats, right?
Yes.
Why'd you say that?
Because that's what I had on for the day because it was a short day. And so it was a dress down day. And that's not unusual.
It was a dress down day, like for the department?
We have a very lax dress code in the Department of Personnel, and from time to time, I do wear sweats depending on what's going on.
Okay. So, all right, so let's talk about the trip to Jefferson City.
Okay?
All right, and Mr. Harris?
Yes.
It is almost high noon, Gary Cooper time, I think. So we'll just take our lunch break and also probably a timely bathroom break, but we'll break for 1 hour. When we come back, Ms. Gray, you'll still be on the witness
okay.
stand. So we're just going to break, everybody go to lunch, and we'll see you back in 1 hour. The meeting is recessed for 1 hour till 1 p.m. We're go off the record now, quit recording. We're back on the record. We'll just resume where we left off. The witness is back on the witness stand and has already been sworn. So, Mr. Harris, you may continue with your direct examination.
Thank you. Director, I just want to go back to what we were talking about a little bit earlier, the recording that you made of Director Byrd. Remember we talked about that?
Yes,
That was a recording that he was unaware of.
that's correct.
When did you make that recording? When did you have that conversation?
We had that conversation on August the 15th. August 15th.
Okay, of 2024?
Yes, 2024.
Okay. And why did you record him?
I made that recording because I had some concerns with regards to whether or not Dr. Byrd had been honest with me or would be honest with me about the things that we spoke about in that meeting.
And can you tell us how did you do the recording? Like, did you use a phone?
No, I used the recorder.
Okay. And where was the recorder?
It was in my office.
Okay, like where in your office?
I don't recall exactly where it was.
So it was out of sight?
It was, actually, no, it was not.
Okay.
If I recall, it was sitting on I think it was on my desk, actually.
Did anyone else know that you were recording?
No.
And that recording captured not only a conversation you had with Dr. Byrd, but also a conversation you had with Stephanie Green.
I think Stephanie came in at the end. Yes.
Right, and that was recorded.
Yes.
Okay.
Just for clarity, it was not a conversation that I was having with Stephanie Green, no. It was an exchange. She was saying that she was leaving to go home, if I recall correctly.
Okay. But don't you also talk about Dr. Byrd in that conversation?
I don't recall.
Okay.
I honestly don't recall.
Okay, all right. But in the recorded conversation you had with Dr. Byrd, don't you discuss with him his recording somebody else?
I don't recall, because to be quite honest with you, I have not listened to that recording in a while.
Would it surprise you if you discussed with him his recording another person, another conversation?
No, it would not surprise me,
Okay, why wouldn't that surprise you?
because Dr. Byrd and I have had a conversation about him recording someone else.
Okay. Tell us about that conversation.
Dr. Byrd recorded another employee. That's pretty much it. He recorded another employee.
And didn't you chastise him about that?
What do you mean by chastised?
Did you tell him that that was illegal?
Yes.
Okay. And were you ever asked about that? Were you ever asked by anyone else about him recording this conversation?
No.
Okay. But don't you say in a conversation with Dr. Byrd that's recorded that you lied about it?
No, that's not what I said. You're mischaracterizing what I said.
Well, you tell us what you said.
Yes. In that conversation with Dr. Byrd, and I told him pretty much what you had just said there. I shared with him, I I think I said something, like I said, because I have not listened to the recording in a while. I think I said something to the effect of a little white lie, or am I going to have to tell a little white lie about this or something like that? But I did not say that I lied, no.
Okay, well, we obviously we have the recording.
Oh, definitely.
And I'm going to ask, we're going to play it.
Let me object. What relevance is the recording? Just,
Your response, Mr. Harris?
I mean, it's relevant to the witness's credibility. She has
How?
indicated that she did not say she lied about it. This tests that evidence. We think this evidence shows that she did say she lied about it. And so it goes to her credibility.
well, Your Honor, she said, she acknowledged, she said something about a white lie, that I might have to tell a white lie at some indefinite point in the future, is what she says. And if he wants to show the white lie clip, I'm okay with that. But if he wants to show the whole thing, that's where I draw the line, Your Honor.
Well,
we're just talking about
Mr. Harris, just to clarify, do you intend to play just a portion of a recording with the portion with about the white lie?
That's correct.
All right, and so Mr. Norwood has said he does not object as long as it's limited to that. So you have a way to do that. Go ahead.
And what the communication was, because I feel like, I don't feel like you 100% trust me, but I do feel like you trust me to a degree, and I wanted you to know, like, hey, this is something that's going on, and it wasn't trying to score brownie points, but it was like,
I didn't take
I
that.
just needed you to know what you're walking into.
I did not take it that
Okay.
way. And my documentation, my wanting you to document it was to protect you. Because the recording that you did was an illegal recording. And so if I did not have you document that you heard it, I couldn't necessarily say, well, he recorded everything, and I'll listen to the recording. So from my perspective, I'm looking at it from a standpoint of what you wrote. This is what you heard, this is what you wrote, but not to have you document it and take it and say, okay, here's what Anthony said. Nobody knows that you were, matter of fact, I think I even told a lie, I said that you weren't even in the building or something like that. So people just know, the people that I talked to, which was in confidence, just know that I got information, it was documented, they don't know where I got it from. It's not my plan to
Okay,
tell
well-
them where I got it from. Because they were able to confirm what it said. You see what I'm saying?
I understand.
So I don't need what you told me now, because I've got them confirming that it was said.
Okay.
All right, now we need to, since that has been heard by everyone here, and it's been introduced in evidence, no objection was made, we need to preserve that recording in some way. You have some method by which you can do that, so that the commissioners need to have
Just that portion?
so that they can, include that in their materials regarding their decision.
Yes, we can. You mean just that clip?
Well, just what you played is all that's in evidence so
Right.
far.
Okay.
So that's, what you played is de facto, it's admitted now in evidence. It'll be considered exhibit number what? 101, 26?
Let's call it 26.
26, okay, exhibit, appointing authorities, exhibit number 26 is a recording that was played. You have a way that's marked in some way, so you know what was played?
Yeah, we have it. We have it marked out.
All right. With that notation, and please do that, and make sure you submit that to the commissioners. You may proceed.
Okay, so you heard the recording.
Yes.
And can you tell us, what were you talking about? You said, in fact, I even lied about it.
Yeah, I'm trying to remember, because that was so long ago, who it was that I had spoken to about that particular situation, because as I recall, I had talked to the city councilor and told her what had happened, and she was the one that told me that it was an illegal recording.
Okay. Okay, that's fine.
Yeah, I don't remember who I would have said that to.
Okay. All right, so let's get back to kind of the details of the trip. We already talked about the conversation where, the vehicle is had, and then Dr. Byrd picks you up, right?
Yes.
Where does he pick you up?
He picks me up at my home.
Okay. Not, at Carnahan Courthouse.
I didn't have a way to Carnahan Courthouse. That was the purpose of me needing a vehicle because I did not have a vehicle.
Okay. All right. And it was, what time did he pick you up?
Around 10 a.m., 10:15, between 10 and 10:30.
Okay. And he's in a city vehicle?
Yes.
So for the actual trip to Jefferson City, did Dr. Byrd drive?
Yes, he did.
Okay. Did he engage in any work on behalf of the city during the drive?
Yes.
Okay, what kind of work did he do?
We both engaged in work.
What did you do?
We both had Zoom calls. We had Zoom calls. We had telephone conference calls. I exchanged multiple emails.
Who did you have conference calls with?
I had conference call with Kathleen Tanner. I spoke with Sarah Baker. We were working on the FMLA project that we had been working on for months at that particular time.
And what about the Zoom calls?
I think the Zoom calls was with, it had to be either with Kathleen or with Sarah. Again, I'm trying to go back and remember back to July 3rd.
Okay.
For a fact, I know that we had conference calls. I can't tell you specifically with the Zoom call who that was with, but I know that I had my laptop and it could have been a Teams call or something along those lines. I didn't go back and pull all of that information.
And during the drive, do you tell Dr. Byrd the purpose for the trip?
No, I do not.
Okay. Your husband is Reverend Darrell Gray?
That's correct.
And was he in Jefferson City that day?
Yes, he was.
And who is Tyra Davis?
Who?
You don't know who Tyra Davis is?
No.
Okay. Once you arrive in Jefferson City, it takes about how long? How long is the drive?
2 hours.
About 2 hours. Once you arrive in Jefferson City, you direct Dr. Byrd where to go. Is that right?
Yes, I do.
Where do you tell him to go?
To my car.
Where was your car?
In the back of the Capitol building.
Okay. And so does he drive you to your car?
Yes, he does.
All right. And then what happens?
He parks the vehicle that we were in. I get out of the vehicle and I go over to my car to retrieve what I came there to get.
What did you go there to get?
I went there to get personal documents.
What personal documents?
It's personal.
All right, and this is, Mr. Norwood, your motion that you raised about personal matters. Now, Mr. Harris, are you intending to inquire in detail about what these personal documents were?
We can move on.
Okay.
We can move on. Okay, so you go into your car and you get these personal documents.
Yes.
And then what happened after that?
I got the personal documents and I went back to the car where Dr. Byrd was waiting for me.
Okay, and then where do you direct him to go after that?
We didn't go anywhere right away. I said, let me get in contact with my husband while we're here. And I said, we can maybe have lunch or something like that. So I proceeded to call my husband.
Okay, and did you reach him?
No, I was unable to reach him.
Okay, what did you do after that?
We sat for a few minutes, and I tried again, and I was still unable to reach him.
Okay, and then, so after the second time you tried, what did you do?
After the second time I tried, I told Dr. Well, I knew that my husband was at the Capitol, and we were parked off to the side, sort of like on the curb, and so we weren't like in a real parking space. So I asked Dr. Byrd to please drive around to the front of the Capitol, and I was going to go in and see if I saw my husband. So we pulled around to the front of the Capitol, and there was a church, and then there was a parking lot, and so Dr. Byrd parked right there.
And there's a hotel there too, right?
No, not where we were parked. There was
Okay.
not a hotel there.
Do you eventually direct him to go to drive to a hotel?
I directed him to drive to the Capitol Plaza Convention Center and Hotel, yes.
Okay, why'd you direct him to go there?
Because
Let me object, Your Honor. How is this relevant? I mean, that's like saying, they took him to the Mizzou ball game and, okay, who scored first and how many subs did they bring? I mean, that's not relevant. The issue is a personal trip. She's acknowledged it was personal, that they took care of business on the way, so I don't understand why.
I mean, I think we get to inquire into the nature and the circumstances of the personal business. It's one thing to just be labeled personal, and maybe that, leads to one decision, either by the commission or her appointing authority, but then to understand what are the details of these personal reasons, and that may, that may lead into or factor into a different decision. I mean, just saying it's personal, but we can't, get into what those personal reasons are, that doesn't make any sense. The whole issue here is why she took this trip on city time in a city vehicle to Jefferson City for these personal reasons. What are these personal reasons we're talking about?
Well, if she says they're personal and does not disclose them, the fact that they're personal has been put into evidence. I don't see what other evidence would be into inquiring what the personal reasons were. How is it relevant whether the personal reasons were she wanted to pick up some tickets to the bowl game, or she picked up, some special candy to take home, or whatever the personal reasons were? I don't see what that has to do with any. She's admitting, as I understand it, that they were reasons that were personal to her. By definition, that means not part of her job duties.
But
if you just clarify that did these personal reasons have anything at all to do with your job, and she can answer that one way or the other. I don't want to presume, but I think that would solve the relevance question.
It's one thing for the finder of fact to hear, oh, it was a personal trip, and so we're going to recommend this. It's another thing for them to hear, well, it was a personal trip and here's what it was, and that may factor into the decision that the commission makes.
I do not see how, unless Ms. Gray tried to raise it as some type of a defense. So the objection is sustained to the question.
And the trip went into after hours, and so that's also relevant.
You can certainly inquire about that. The only objection was to a question about further detail about what these personal items were that she picked up and what personal matters she discussed.
Well, not the personal items in the car.
Okay.
I'm not asking about that.
Your question was just about what she discussed that were personal to her, was her answer, right?
Right. So the question is about, the reasons for the trip, the details of the reasons for the trip. I mean, how is the commission going to be able to make a recommendation here when all they know is it was a personal trip versus, well, it was a personal trip and here's what happened?
Well, Your Honor, it's just like in court, right? If you stipulate a fact that's critical to the determination, then it's stipulated, right? You're talking about wasting time. This is a waste of time to be going down in her personal affairs with her husband.
Calm down, Mr. Norwood. I'm sustaining your objection. I'm sustaining your objection.
The flow is flowing. I'm sorry, Your Honor.
Mr. Harris, I'm sustaining his objection. Let's move on.
Okay, so you go to Jefferson City for whatever these personal reasons were.
Yes.
That, despite, all of the bluster that we've heard here thus far, from your counsel that this is all hyped up and everything, but we can't know what those personal reasons really were. So, so you get there with Dr. Bird, and after that trip is over, you head back.
Yes.
Okay, and Dr. Bird is driving?
Yes, he is.
Okay. On the trip back, are you doing any work?
I did do some work. I did respond to a couple of emails during the trip back.
Okay.
But that's, yeah.
And what what's your emotional state while you're driving back?
Well, the objection, Your Honor, her emotional state, how is that relevant?
How is that relevant, Mr. Harris?
Again, we're on this issue of what were the details and circumstances of this trip.
All right.
I mean, I don't know. I
I'm
don't know
just
what
going
the-
to confer
what the
with the
commission's gonna do.
commissioners here briefly. All right. The objection to the question on the emotional state is overruled. So, Ms. Jenkins, you understand the question he asked you about what your emotional state was on the drive back?
Okay.
Well, let me object, Your Honor. I mean,
Well, I overruled your objection.
well, I know, but I think, I mean, I don't understand the relevance. How is that relevant? You know, I mean, you know, on the record, her emotional state, I mean, what's your emotional state today? I mean, who cares? I mean, the whole point is, it's a personal trip. She went there, she came back, and that's the issue that this commission has to decide. Her emotional state, first of all, shouldn't factor in your determination, right? It has nothing to do with the issue of malfeasance, right? I mean, and so to be here in this public body, getting into her emotional state in public, her private mental state, has absolutely zero bearing.
I didn't ask about her mental state.
Listen, let me finish.
Asked about her emotional
Let me
state, not her
finish.
mental state.
Let me finish. Has zero to do with this matter before the tribunal. And to allow him to delve into personal emotions is wholly improper and a violation of her rights to privacy. She has a right to privacy. She didn't give up that right to privacy when she agreed to accept this position. There's no dispute that there was a travel on a personal nature. And the court, the tribunal, I'm sorry, decides, okay, is that malfeasance? But to allow this probing for something that has zero relevancy is shocking to me. And I just want a clarification as to the mindset as to why the court, the tribunal, feels this is relevant to anything.
Well, let me just say,
The objection's overruled.
okay, for the
Right.
record,
Yes.
counsel held up the baggie of, I guess, $170 and said, that's what this is about.
That was not during the evidence, Counselor.
Okay.
All right, let's stick to,
Well,
we're
okay.
now in the evidence.
All right.
Okay, I've overruled the objection, but just state your question again for the
Okay,
witness.
thank you.
Sure, what was your emotional state on the trip back?
My emotional state on the trip back was one where I was concerned.
What were you concerned about?
Objection,
Something
Your Honor.
personal.
Objection, here we go. Now we go down the rabbit hole of emotional states and the whys and the wherefores, and how is this relevant to anything? This is a prime example of why we're here. This is character assassination, right?
So we're certainly not here for just $170.30 in a baggie, just to make that
Mr.
clear.
Harris, the objection is overruled because the question was, what was your emotional state on the trip back? And the answer was, I was concerned. The question then was, I believe, Mr. Harris, you want to restate your question? The one
Why
that-
were you concerned?
And why were you concerned is simply because that concern is not specific enough to tell us anything. So, Ms. Gray is the only one who can answer this question as to what she was concerned about. Overruled the objection.
So what I was concerned about was something of a personal nature.
Okay. And so you said you made some business calls on the way back. Is that what did you say that?
Yes, I did.
Did you call anybody else for non-business purposes?
Yes, I did.
Who'd you call?
I called my father.
Okay.
I spoke to my daughter. And I spoke to a friend of mine.
Okay. And why'd you call them?
Objection. What relevance would that have? I mean, why do you call your family? Is that where we're going? Is this what due process is in today's society?
All right, the objection's overruled. You
Okay.
understand the question?
Please answer the question again.
I said, why did you call those folks that you just mentioned?
I talk to my father 2 to 3 times a day. I talk to my daughter 3, 4 times a day. I called a friend of the family, a friend of mine, in which our conversation was completely confidential and protected.
Okay.
But I don't know if this is proper or improper because I've never gone through anything like this. But for the record, my was specifically to get those documents.
But you were asked by them what those personal papers.
No, I was not.
Oh, you weren't asked that?
No, I was
Okay.
not.
All right. Okay. That would be odd that if they never asked you.
They never asked me.
Okay. All right, and again, so Dr. Bird is driving.
Yes.
All right, and about what time is this?
It was nearly dark. I can't tell you exactly what time it was, but it was almost dark.
Okay, it was after 5 p.m.?
Yes.
After normal business hours?
Our business hours aren't normal again. Dr. Bird and I work
You work
24/7.
24/7.
I do, literally, 24/7.
But after normal business hours is when you got back, right? It's dark out.
It's dark.
And where do you direct Dr. Bird to take you?
To my home.
Okay, and does he do that?
Yes, he does.
All right, and then what happens at your home?
When I get to my house, I realized that I did not have my key and my husband had not arrived at the house yet.
Okay, he was on his way back.
I'm sorry?
Your husband was on his way back.
I'm assuming that he was on his way back. Yes.
Okay. And so you realize you don't have your keys, so then what happens?
We wait for a few minutes.
All right. And you wait for a few minutes. What happens after that?
He did not come home.
So do you direct Dr. Bird to drive you somewhere else?
Yes, I do.
Okay. Where was that?
We drove to the Hollywood Casino because that's where my car was.
How do you know your car was there?
Because I can track my car, GPS.
Okay. So when you're driving back, you're able to track where the car is. While
No,
you're
on
driving.
my way back, I did not track where the car was. I did not track my car until I arrived home to see where it was or where he was.
Okay. And then you tracked it, and it was at Hollywood Casino.
Yes,
So you direct him to go to Hollywood Casino.
yes,
All right. And you direct him to go there so you can retrieve your keys,
yes.
which you had not retrieved when you were in Jefferson City.
There was no reason for me while I was in Jefferson City to retrieve my keys. That's not what I went there for. I had gone there specifically for the reason that I stated earlier. When I got back home, I realized that I realized that my key was not on my key ring. It usually is, but I gave it to the young lady that babysits for my dogs.
Okay. So you go. So he takes you to Hollywood Casino in Maryland Heights.
Yes,
Again, it's dark out after hours.
yes.
Okay. What happens when you get there?
We found my car, and I proceeded to go to the car to get my spare key out of the console.
Okay. And you did that, and then what happens after that?
After that, I get back in the car with Dr. Bird, and we proceed. And I don't know if we went back to my house or if we went to my daughter's house. I'm not sure in there because, again, it's been a while ago, and I just don't remember. I don't recall.
And during the trip from the casino to one of those two places, do you play a recording for Dr. Bird?
No, I did not.
You did not.
I did not.
Okay. You don't play a recording of what was recorded in that vehicle that day?
No, I did not, no.
Okay, all right.
And I know that, yeah, no.
You know that what?
From Dr. Bird's,
Deposition?
yeah, or testimony that was mentioned, and I couldn't say anything during that time. But no, I did not play a recording for Dr. Bird or play a recording for myself.
Okay. But didn't Dr. Bird express to you that he was concerned, that he was worried about his safety?
Well, let me object. First of all, it's hearsay, number one. Number two, relevancy.
It's relevant, once again, the commission and then the appointing authority has to make a decision here. And what part of that is, was this malfeasance? And in all of that, the director's judgment is in question. And so that's where all of this goes. Did he express concern for his safety?
Director's judgment as to what?
All right, the question is, did Mr. Byrd express to the witness any concern for his own safety? The objection to that is overruled. The witness may answer.
It's hearsay, Your Honor. It's hearsay.
It's not, as I understand it, it's not being offered to prove the truth of a statement, or is it?
What is it being offered to prove?
I mean, it's offered to prove the witness's credibility, and it goes to the issue of whether or not this witness would put her own employees in certain uncomfortable situations.
I will draw the objection.
All right.
Please
Did he
answer the
express
question.
concern for his safety?
No, he did not. Not at all. He did not express any concerns for his safety, nor did I have any concerns about my safety.
Okay. You were there at the deposition,
Yes, I was.
and you recall his testimony.
Well,
Yes.
Let me object, Your Honor. She shouldn't be commenting on somebody else's testimony at a deposition.
She already did.
Well, gentlemen, actually, that's premature. It's not really much of a question because she already has talked about having been at the deposition, so that's not in dispute. She was at the deposition, so
Well, we have a
what is...
transcript of the
So
deposition,
what is the question, and then I'll hear your objection, all right? I didn't really hear a question yet.
Well, the question was, you were at Dr. Bird's deposition.
No, she's admitted that. What's the question?
The question was, and it goes to, did he express concern for his safety at that point where you described where you guys are from the casino?
Asked and answered.
The objection will be sustained in the sense that you're now asking her to recite her memory of what a different witness testified to in his deposition. So the deposition, if it's offered, would be the evidence of what that witness said.
Okay,
Her
and so-
memory as to what it is irrelevant.
And so you direct Dr. Bird to drive you from the casino to either your daughter's house or a friend's house?
No.
Well, okay.
I directed him to drive me either to, I was trying to remember if I went back to my house or if I went to my daughter's house. I think I probably went to my daughter's. Okay.
And so when you went to your daughter's house, what happened?
I went to my daughter's house. I called her. She came downstairs. I got out the car to talk to her privately. We talked, and I got back in the car.
Was there an argument? Did you
No.
have an argument with her?
No, I did not have an argument with my daughter.
Okay, and Dr. Bird then didn't get out of the car and go over and talk to your daughter?
I don't recall Dr. Bird getting out the car, but that would be something that you would have to speak to Dr. Bird and my daughter. I don't recall that.
Okay.
But I do know that I did get out the car.
Okay. And then, so when you get back in the car, where do you direct him to take you after that?
After I left my daughter's house, I went to a friend of mine's house.
Okay. And how far away was that?
Maybe 2 miles. Not very far.
Okay. So, and when you direct him to take you to a friend's house, what happened after that?
He dropped me off at my friend's house.
Okay. And what time was that?
I do not know.
After midnight?
No, I do not believe it was after midnight.
Close to midnight?
No, well, I can't recall, so I can't say if it was or if it isn't, but I do not believe that it was that late.
Okay, so you can't recall, but you know it wasn't after midnight.
I don't believe it. I said I don't believe that it was after midnight, but because I can't recall, I can't say 100% for sure.
Okay. And then, so that's July the 3rd.
Yes.
Okay. Do you then have a meeting with Bianca Lambert and John Understall on August the 15th?
Yes, I did.
Okay. And was it in the afternoon?
Yes.
All right. Who is Bianca Lambert?
Bianca Lambert is an HR manager within the personnel department.
And who is John Understall?
John Understall is one of my deputy directors.
And where does this meeting take place?
In my office.
And in this meeting, what, if anything, did Bianca tell you?
She came to my office because she wanted to talk with me, and she started the meeting out by telling me that the reason that she told me that morning that she was upset was a lie.
What else did she tell you?
She told me that the real reason that she was upset that morning was because she could no longer work with Anthony Byrd.
Okay, and why did she say that?
She said she could no longer work with Anthony because her kind of exact words were, Anthony's, forever harassing me, and he's always wanting to talk to me, and I expressed to her that Anthony was not in her direct chain of command, and that she did not need to be worried about leaving the department because of Anthony.
Okay. And did you, when she expressed those things to you, did you have concerns about Anthony Byrd?
I have always had concerns about Anthony Byrd.
What kind of concerns?
I've had employees within the department come to me to share concerns about Anthony. And so there was a heightened awareness that there potentially could have been something there.
Okay, and so what kind of things were you worried about Anthony Byrd?
I cannot get in
Let me
context with
interject.
Anthony's
I mean,
performance.
Anthony's somewhere who knows
Yes.
where, and here we're getting into his personal
Right.
issues
Okay.
in this tribunal.
I'll move on.
He's withdrawn the question.
I'll move on.
Okay.
So, but you have testified that you had concerns. You said you've always had concerns. That's what you said.
I've always had concerns based off of information that was provided to me that I did not verify.
Oh, but you didn't believe any of that stuff.
No, right. I didn't give it much credence.
And that's why you felt you could trust him to get you a car on July the 3rd.
No, that is not true. That is not why I trusted him.
Okay.
To believe that he could get me a car.
Why did you trust him to believe?
I trusted and believed that he could get a car because Anthony always drove city cars, and so therefore I believe that his knowledge of policy, etc., governed getting cars. And so, like I do with all my deputy directors, whatever their areas of expertise is, I will go to them for advice because I'm not necessarily knowledgeable of all city policies and nuances.
So then you don't have any trust issues with Dr. Byrd. You can trust him.
At that particular time, I wouldn't. Well, it all depends on what you're saying as far as trust. So, what do you mean when you trust him with what?
I mean, what do you mean? You on the recording, you said you trust him. What did
I
you mean?
trust him with regards to giving me accurate information with regards to carrying out the duties and responsibilities of the Department of Personnel.
So when Bianca Lambert came to you and said she's having all these problems with him, that didn't really concern you.
Objection that I'm used to standing up. Objection that mischaracterized her testimony.
Overruled, but you're starting to wander a little far afield here. I'll allow this question. Do you understand it?
Could you please repeat the question, Attorney?
I said when Bianca Lambert came to you to, said she had these complaints about Anthony, she can't work with him any longer. That didn't concern you.
It did concern me. That's why I reiterated to her that Anthony was not in her chain of command, and therefore she did not have to interact with him on a daily basis.
So what else did she tell you in that meeting on August 5th?
Okay. In that meeting, then she recanted, and she said, well, there's something additional. And I said, okay, what? And then she proceeded to tell me that Anthony had shared with her that he and I had gone to Jefferson City for personal business in a city vehicle.
Okay. And I'm not, and because of the rulings here, I'm not going to ask you about the details, but she got into detail, didn't she, about that about the personal nature of
Yes, she did.
Okay. And then how did you respond to that?
I responded to her by saying these exact things. I said, I see two issues here. I said, I can address both of them. I said, the first issue, the things that you have mentioned from a personal nature, completely are not true. I said, however, I said, I did take the car for a personal reason. And I said, if my taking the car violated any policy, then I am going to go to the mayor's office and self-disclose, because I do not operate by doing things and then being made aware that they're wrong and not handling it.
Because you didn't know that it was against the rules or against the policy to take a vehicle on an out-of-town trip during business hours for personal reasons. You didn't think that was a problem.
I did not think it was a problem.
Okay. And you told her you were going to self-report.
Yes, I did.
Okay. And do you have more conversations with Bianca Lambert after that?
We talked the next day. And I recall the conversation being, and I'm paraphrasing at this point because I can't say exactly what was said, but I do recall the conversation where Bianca told me that I should go to the comptroller's office and tell the comptroller what I had done, and that typically restitution is made for this type of offense. I proceeded to tell her, though, that I'm still going to go to the mayor's office and let them know what I've done. I cannot not go tell on myself, pretty much is what I said.
And Bianca is a subordinate, right?
Yes, she is.
All right. You don't report to her.
No, I don't.
She reports up a line to you.
Yes.
Okay. And yet she's telling you you need to go to the comptroller's office.
That's what she said, yes.
Okay.
I did not solicit that information, but that's what she said.
And did you ask around about, hey, what do I do since I, violated this policy?
I did.
Who'd you ask?
First of all, I needed to understand if I had actually violated the policy, so I called I called an appointing authority who actually has a city vehicle to ask whether or not I violated the policy or what is the policy, because at that particular time I did not know where the policy was located.
Because again, I just want to be clear. So you've been in HR for how long?
30 years.
Okay. And you didn't know that it would be a violation or it would be something wrong with a director of personnel, you, the highest ranking HR person in the city, taking a city vehicle during work hours with a subordinate employee out of town for personal reasons. You didn't think that might be a violation.
So my experience of 28 years, because I've been with the city for 2 years, is that I've had cars before. I've had organizations give me cars, used cars, etc. And it is completely okay to use a car for personal reasons. And typically what I would do is reconcile at the end of the month or whatever that period of time was with that organization, reimburse if I use, if it was for personal use, etc. So this is the first time where I have not been able to use a company car for personal reasons.
Did you try to reconcile at the end of the month, end of July?
I'm sorry?
Did you try to, you said typically you would just reconcile at the end of the month. Did you try to do that at the end of July here?
I did not do that at the end of July here because I was led to believe that it was completely okay and that there was no reason for me to reconcile. You have to understand something. I didn't even know that you could reserve or use city cards. I didn't find that out until May of this year, and I've only been in a city car twice.
So you were led to believe that by whom? By Dr. Bird?
I am in no way blaming, first let me say something, I am in no way blaming Dr. Bird for this. It is my responsibility, but I trust it because of his expertise in city vehicles and using city vehicles, that it was okay.
His expertise in using city vehicles.
Yes, because he uses them on a regular basis.
You've got deputy directors, don't you?
Anthony is my chief administrative officer. My deputy directors for their areas of expertise, I depend on them for those areas to tell me if I am doing something wrong or should not do something.
But so I guess that begs my question. You never went to one of your deputies to say, hey, is this okay that I use this vehicle for these personal reasons?
My deputies would not be one that I would go to for that type of question for this. It would have been my chief administrative officer who, for all of the administrative responsibilities and things of the Department of Personnel, I depend on him for.
And it wasn't until a month and a half later when someone else tells you that you've been outed that you seek to reimburse the city.
I did not know I did anything wrong, so why would I seek to do anything different?
Okay, but again, you didn't do this whole try to settle up at the end of the month. This happened July 3rd, right?
Are you speaking from a standpoint of based off of my corporate experience? Would I have tried to settle up?
I'm saying you said you would typically settle up at the end of the month, and you didn't do that here.
I didn't do that here because I didn't know that it was required here. Required. If I had known that, then I would have done that.
Okay. So then, so you have these conversations with Bianca. Was it more than one conversation after the August the 15th?
There were two conversations.
Okay. And was it over the weekend?
No.
You didn't talk with her over the weekend at all?
I don't believe I would talk to her over the weekend, no.
Okay. And are these are conversations still around this incident from July 3rd?
Yes.
Okay. Are you asking for some more advice from your subordinate?
No, I'm not.
Okay. All right. You're just discussing with her this
No, we
trip.
had the one conversation that I just mentioned to you. And the only other conversation that we had was the day that I went over to meet with Sarah and Jared.
Okay. So do you believe that having Dr. Bird tell you that it's okay to take this trip with this car, that made it okay?
With the information I have now, no, it was not.
Okay. But at the time, you thought it was okay?
At the time, I thought it was okay.
All right. And you were asked, I take it, to provide a written statement, is that right?
That's correct.
And you provided that statement?
Yes.
Okay, but before we get to it, do you have a meeting with Jared Boyd and Sarah Baker?
I do.
Okay, and who are they?
Jared Boyd is the chief of staff to Mayor Jones, and Sarah Baker is the deputy chief of staff.
Okay, and do you meet with them on Monday, August the 19th?
Yes, I did.
In the afternoon?
No, it was in the morning. I don't know what time it was, whatever time you have. I thought it was that morning at 11 o'clock.
Where did that meeting take place?
In Jared Boyd's office.
And you were asked about this trip to Jefferson City?
Yes.
Okay. And you admitted taking the trip?
Yes.
All right. And you admitted that Dr. Bird drove?
Yes.
Told them that Dr. Bird said it was okay?
Yes.
Okay. And again, you provided a written statement?
Yes.
Take a look at Exhibit 2.
Yes.
That's the statement you provided?
Yes.
Your signature's on the second page?
Yes, it is.
Okay. I would move for the admission of Exhibit 2 into evidence.
No objection.
Appointing authorities Exhibit 2 is admitted into evidence.
And in the written statement, you acknowledge that it was true that you violated this policy. In other words, that you took this vehicle to Jefferson City for personal reasons.
Yes.
And then do you meet again with Sarah Baker and Jared Boyd?
Yes.
And was that on August the 22nd?
Yes,
Was that in Jared Boyd's office?
yes.
And is that the time that they inform you that they're going to provide you with a pre-termination notice?
That was not the only thing that they provided me with.
But they provided you with a pre-termination notice? Or they told you they were going to provide you with a pre-termination notice?
Yes, they did.
Okay, and then we looked at that, which was not government, which was Exhibit 1, right?
Yes.
Okay. When they tell you that they're going to provide you with this pre-termination notice, how did you respond?
I was shocked. I think I was probably speechless for a few minutes. I told Jared that I was going to fight this, and that I did not, pretty much that I was going to fight this. And then he proceeded to say, well, we would be willing to accept your resignation. And I said, no, I'm going to fight this.
Okay. All right, and we've talked about, it's been alluded to that you reimbursed the city, is that right?
That's correct.
And
Yes.
by paying a check in the amount of, I don't even remember the amount, $170 and some change?
Yes.
Okay. And tell us again, how was that decided, that was the amount?
Based off of the mileage
Okay.
that I believed had been utilized on the vehicle, as well as the IRS's going rate for vehicle mileage reimbursement.
Okay, and but the reimbursing, the idea of reimbursing, that was Bianca Lambert's idea?
She told me what the process was in the city of St. Louis for something like that.
Okay, all right. And again, that's something you didn't ask any of your deputies about?
Well, I didn't have an opportunity to ask them because Bianca volunteered the information.
And you just figured, well, this must be right?
Well, that's why I went to ask the question first of the comptroller's office. Before I went over, I did call the comptroller's office and ask for a copy of the vehicle use policy, or where I could find the vehicle use policy.
The conversation that you had with Sarah and Jared on August the 22nd, where they tell you, we're going to give you this pre-termination notice,
Okay.
right? And you were shocked. They say, according to you, they say, or you can resign, and you said, I'm not going to resign, I'm going to fight this.
Yes.
What else do you say?
I don't recall saying anything else. I remember getting up and leaving.
What about in the first meeting you had with them
Okay.
on August the 19th? And they tell you, hey, we got this information that you violated the policy, and you tell them, we took the trip, but this other personal stuff, these other personal details, that's not true. What else do you tell them?
In the first meeting, the first meeting that I had with them, the meeting was primarily about my husband and my relationship with him.
Okay, all right. So, and we can't get into that, obviously.
Right.
But anything else?
Not that I can recall.
I mean, this July 3rd issue comes up. They tell you, this is what we heard. And you say, well, that part's not true, this part's true. You talk about your husband, that's it.
In a nutshell, yes. That's what I can recall.
And then, you've spoken with Bianca, and she's told you about reimbursing the city, right? Do you ever, your appointing authority is the mayor's office, right?
My appointing authority is the mayor.
Yeah.
Yes.
Do you ever ask Jared and Sarah, who are chief of staff and deputy chief of staff, what if I reimburse the city? Do you ever bring
No,
that up?
I did not tell them that. I did not ask. I did tell them that I'm going to reimburse the city. Yes.
Oh, so that is another thing you told them.
Yes. Now that like I said, I don't remember everything. but
You didn't really tell them that, did you?
yes, I did.
Okay, all right. You, have you, you've violated city policy before, haven't you?
Yes, I have.
In what way?
Well, let me object because, I mean, we're not here on other violations from my reading of the notice, so we object.
Well, the notice does say that her prior work record would be considered.
Well, Your Honors, Your Honorables, let me, if I could, without grandstanding, because I sense that this would be an area, and there's a case that makes clear, crystal clear, that the notice has to be specific so that for lawyers, for accountants, for reverends could prepare to come in here to defend charges. Now we're skirting into what? I mean, you can't just have a statement and anything else. I mean, is that due process? We object. The law is clear on that.
It's in the notice which she received way back on August the 23rd.
The law, our law, that governs us all, says that the notice has to be specific because due process of law requires such specificity. And in fact, the charter provision provides for such specificity. So to say anything we can come up with between now and the hearing is wholly improper.
The notice reads,
All right, let me just say, the objection's overruled. The notice does have that statement. I believe that statement is taken from the Civil Service Commission rules that at such a hearing, the employee's work record is to be considered, and further that the notice to the employee is supposed to say that, I believe. Now, I could be wrong on that, but at any rate, it is, those words do appear in the notice that has already been talked about at length. Her prior work record, for good or bad, therefore can be considered in this hearing. Now, we're not going to relitigate anything in the prior work record. It's whatever is in her prior work record is what's relevant.
Your Honor, I'm here to address a charge of malfeasance associated with use of the vehicle.
Right.
That's what I prepared for. That's why I brought my team in here. We've got a lot of malfeasance-related documents in here. But, and so to say that now we can go into, I don't even know what he's about to go into, quite frankly, but to say we can go into whatever he's going into without proper notice, to me, I mean, she may have a whole lot of information, but I don't know about it.
All right.
I'm entitled to the notice. I'm entitled to know what kind of Bush League ambush I'm walking into.
Well, the objection's overruled. It's in the notice, and it is something that can be considered. Now, your question, Mr. Harris, or questions certainly have to be focused on something that is in her prior work record. We're not going to relitigate anything disputed in the past. All right?
May I, Your Honor?
So,
Swartz versus City of St. Louis, 274 Southwest 3rd, 509, Moab, Eastern District, 2008. And I'm going to just read from the court, and then I'm going to sit down, and you all can do what you want to do. Quote, an employee must receive sufficiently detailed notice so that he or she can protect him or herself from an unfair disciplinary action. Adequate notice permits an employee to be heard at a meaningful time in a meaningful manner by allowing the employee enough information to be able to defend the allegations and to present conflicting evidence in a timely manner. This means generalizations are not sufficient. Instead, specific details regarding the employee's alleged misconduct must be stated. Must. Those details must be sufficient to enable the employee to understand the basis for the disciplinary action and to be able to oppose the action, which was in the motion that we filed to preclude this, that the body apparently denied, ignoring the Eastern District Court of Appeals. This is not Ronnie on the law, this is our law.
All right, and forgive me, what was the page, volume number and page number of Southwest Third? I didn't catch it.
Judge, I'll give you a copy of our motion that has the Swartz decision.
All right, it's in there. All right, 274 Southwest Third, 509, right? Okay. So, you've made the record on your objection. Now, again, the objection's overruled. Ask the question. It has to be specifically directed to something in her work record
Correct.
to fall within what I just ruled on.
So I asked her if she's violated the policy before. She said yes, and I didn't get to go on.
Well, Your Honor, that's not what the case says. It doesn't say it has to be specifically worded. It says the notice
I
has
understand.
to be specifically detailed to afford her a right to due process.
The notice is detailed in talking about the violation of the vehicle policy, so the notice is detailed. But the
All right.
notice also allows for getting into the employee's prior work record.
The case law says no.
Well,
don't think that's what the case
Mr.
law
Norwood, you have not persuaded me with your citation
Okay,
to
fair enough.
Schwartz versus City of St. Louis.
Fair enough.
As you said, I may be right, I may be wrong. All right? So we'll move on, though. The objection is overruled, and
Okay,
ask the question specifically for the witness.
all right, okay,
You violated city policy before.
I have.
Okay. In what way? What did you do?
In October, November of 2023, I took a city trip to Harvard to attend a class. Upon my return from that class, I had parked at the St. Louis airport, and I used my department credit card to pay for my parking, which was $102.
And in that case, didn't you say you didn't know what the policy was?
I didn't know what the policy was. I have never received the travel policy from the City of St. Louis, and that was my first time ever traveling.
Okay, so you didn't know what the policy was, the vehicle policy, and that's how you ended up violating it. And then again, back then, you didn't know what the credit card policy was, and that's how you ended up violating it. That's what you're saying?
Yes, that is what I'm saying.
And you are, again, the personnel director of the City of St. Louis.
Right. I am the Director of Personnel for the City of St. Louis, and upon my hire to the City of St. Louis, I've never received any training, any onboarding from my appointing authority with regards to policies, et cetera. Municipal government was completely new to me, and so I pretty much have been having to learn on my own. And that's why I depended on my deputy directors and Dr. Byrd with answering questions and leading and guiding me, because I didn't even know where to go find policies, to be quite honest with you. And when I did violate that policy, and I was made aware that the city does not, most companies, if you travel on business, city business, company business, they cover your travel, they cover your taxi to the airport, wherever. But the City of St. Louis, for whatever reason, they don't. And so when that was brought to my attention, I paid restitution.
And as you said, that was October, November 2023, right?
That's correct.
That was a policy violation.
Yes.
And you didn't get disciplined, did you?
I'm sorry?
You didn't get disciplined for that, did you?
No.
Nobody came and hit you with a pre-termination notice, right?
Correct.
You had some political differences with the mayor's office at that time too, didn't you?
No, I did not.
Oh, okay. What about your husband? Didn't he have some differences with City Hall and the mayor's office back then?
At that particular time, I cannot answer that.
Okay. But nevertheless, you violate this policy October, November 2023.
Yes.
and nothing happens to you.
Correct.
In fact, you've been the director of personnel since that time.
Yes.
And so you don't get trained? You don't have any training?
I have received, like other cabinet members within the last 9 months or so, trainings that the city councilor and myself have identified that needed to be conducted for cabinet members because training had never been done for any of us. Yes.
So, okay, so the truth is you are being trained.
No, that is not the truth. When I came on board, November 22nd November 7th of 2022, at that particular time, coming into a new role, such as the Director of Personnel with the nuances with municipal government, in which I had never worked for municipal government, there was no onboarding, no training, no meetings with the mayor, no meetings with anyone that helped me govern the nuances of city government.
And you stuck around, right?
Oh, yes, I did.
Okay.
That was not a reason for me not to.
You understood from the beginning of this, whole process, right? Since July 3rd, and since let's say since it came out that this happened.
Yes.
That Dr. Byrd was going to be a witness in this whole thing, right?
Yes.
Okay. And you delegated to him the issuance of subpoenas, didn't you?
Yes.
Because, that's part of your job as Director of Personnel. You're a secretary in the commission, right?
Yes.
You deal with subpoenas for hearings.
Yes.
And you delegated to a witness, Dr. Byrd, this job of issuing subpoenas.
Is that a question?
Isn't that right? You delegated to him the issuance of subpoenas?
The issuance of subpoenas was delegated to Dr. Byrd, as well as continuing his duties as secretary with the commission going through all of this. Unbeknownst to me, Dr. Byrd has been solicited by the commission as well as by the commission's attorney to continue in the process with helping them to coordinate and plan and come up with procedures for this hearing.
And you signed his subpoena, didn't you?
I'm sorry? Yes, I
signed
did.
subpoenas.
I did.
And he signed the one for you, right?
That's correct.
Okay. And so you sign this key witness's subpoena, he signs yours, and your lawyer is screaming about due process, your due process rights being violated.
Just for clarity.
That's her attorney who you're referring to, all right? So.
Yeah.
Yes. And for clarity, within the Civil Service Commission and signing off on subpoenas, it's just a matter of signing off on them to issue them. The signature actually means nothing other than we received it and this subpoena will be issued.
I have no further questions.
All right, we'll take a bathroom break real quickly here, and then we'll proceed with cross-examination. So I got 7 minutes after 2. Let's just make this a 5-minute break. I think is long enough. 5 minutes.
Well, Your Honor, I need at least a minute to back up my stuff, so can we add an extra minute?
8 minutes, how's that?
Perfect. Thank you.
2:15. All right, then, everyone is back from the break. Mr. Norwood, we were ready for you to proceed with your cross-examination of your client.
Just one moment. I'm a little bit discombobulated here.
All right,
Bear
we'll
with me.
give you a chance to uncombobulate.
Yeah, please, thank you, Your Honor. Thanks for your indulgence, Your Honor.
No problem.
If I may,
You may proceed.
thank you, Your Honor. Too much paper, Your Honor, sorry. Okay. Good afternoon.
Good afternoon, Attorney.
How you feeling?
I feel okay.
And just for the record, did you have an accident recently?
Yes, I did.
Tell us a little bit about that.
Oh,
And you object to the relevance of that?
Mr. Norwood, relevance?
Well, I mean, she's, not in the best of states, and I think you all need to understand that as you evaluate her testimony and credibility.
She just said she felt good.
no, I didn't finish.
Well, I think you would need to establish that she is somehow hindered here today. Your question, I don't think, was just, have you had a recent accident? Tell us about it. So that's a little broad and vague. You want to focus in on whatever the problem is that you think is affecting her ability to testify?
I don't know if it's affecting her ability to testify or not, but I can make an offer of proof. I mean,
All right, what is it?
she had an automobile accident, maybe a week or two ago. She was driving. She was T-boned, I understand, by a vehicle, I think seated vehicle maybe, or
Yes.
and which required her to go into the emergency room in the hospital, and she's limping around today. So my offer of proof is simply that in evaluating her, and if she, seems maybe uncomfortable, that's something to be taken into consideration. That's my offer of proof. I'll move on. Thank you, Your Honor.
Well, the question, in other words, to your witness would be, is all of that you just related true?
Oh, that's my.
In other words,
if I was able to examine her.
I'm going to
record-
allow you to lead it to just allow us to move on.
Okay.
So.
It's all of what I just relayed true, and if not, you can clarify or amplify for this record any way you see fit.
It is all true, and that is the reason why I am limping. My leg and right side was somewhat injured.
Thank you. And we've got a lot to unpack, and I don't know how many days we have for the hearing. A lot to unpack, and I want to unpack it because I think it's important for the tribunal and for the public to know. Let me start by handing you a document that's marked as Respondents Exhibit 12. We have copies for. Just give it to you.
Thank you.
Okay.
I'm going to object to the relevance of the document as well. It's completely irrelevant to the issues in the case.
January 2025. Well, of course, the document itself is, it doesn't tell us, when it refers to attorneys, are these attorneys that are attorneys for the city, or are they private attorneys?
It's me.
Okay. And the relevance of this would be what?
The relevance is to the credibility of the lead investigator, the person who put together a letter, which also had some problems. We're going to talk more about that. And I think it shows the intent, the callousness, the downright mean-spiritedness of what this is all about. Our whole, one of our defenses, we got many. First of all, this doesn't qualify as malfeasance under any way, shape, or form. But our view of the world, rightly or wrongly, and you all have to decide if I'm right, is that this is a power play, a vindictive effort to destroy this civil servant. And there's no better illustration than this email that is a pack of lies by the chief of staff. Let me finish. Let me finish.
Testifying.
Let me finish.
The question is, what's the relevance?
Mr. Norwood, that's correct. The question is, what's the relevance?
It's
The
relevant.
document itself is very brief. If
Yeah.
I'm looking at your Exhibit 12.
Yeah, very-
It's 2 sentences.
Yes.
And the sentences are not clear about what it's talking about, so it is impossible to know whether this has anything at all to do with anything.
Well, may
Now,
I?
You
Voir dire the
you
witness?
say it is because you're going to show that this is some kind of a power play. Am I correct?
Yes, absolutely. Harassment. One of the issues is harassment, retaliation by the mayor and their personnel. That's central to the case.
All right. I'm going to overrule the objection and allow you to ask about this exhibit, but you're telling me you're going to somehow be able to tie
It's
this
short,
up
short,
with evidence
sweet, to the point.
about what you're claiming, all
Yes,
right?
yes,
All right,
absolutely.
objection's overruled, Exhibit 12,
Your Honor,
you're offering it, go ahead.
You beat me to the punch. I was going to withdraw. I don't care about that.
Okay.
Okay. What is Exhibit 12? I'm sorry, I haven't given you Exhibit 12. No. We can put that away for now, because there's some stuff in there.
Okay.
What is Exhibit 12? Respond to Exhibit 12.
Exhibit 12 is an email that I received from the Chief of Staff, Jared Boyd.
When did you receive that email?
I received it on January 2nd, around 3:30 in the afternoon.
Okay, so let's take a look at that email dated Thursday, January 2nd, 2025 at 3:25 p.m. And on the subject line, it says, personal attorneys on city premises. You see that?
Yes,
And what city premises is he referencing?
the Carnahan Building.
Okay, so there are a lot of personal attorneys running around the Carnahan building right now. I think we could stipulate to that, right, counsel? Okay, oh, you don't know, okay, there you go. All right, so personal attorneys on city premises. Sonia, we received a complaint this afternoon that your attorneys are spending the day in the personnel department. Can you confirm this? You got that email.
Yes.
How did you feel when you got that email?
I felt very, very bad. I felt that Jared believed that I was doing something wrong. It became very concerning for me because of this current situation, and I'm saying, is this just more stuff that they think that I've done wrong? And so I reached out and forwarded the email to my attorney.
Okay, all right. Are you aware of any policy that prohibits personal attorneys from coming into the Carnahan building, which is a public building, for any reason? Are you aware of any policies of the city that make that a problem, to your knowledge?
No.
So do you know why the chief of staff of the mayor, the most powerful executive in the city, would send you an email complaining about your personal attorneys being here in this building that's open to personal attorneys from all over the free world? Do you have any reason, understanding why this individual would do that?
No.
Without revealing attorney-client privilege. How long were we here?
No more than maybe 15 minutes because we weren't even together. I left and went in my office to work.
And from what you observed, without getting into discussions, why were we here?
To review this room here for its technical capabilities.
Okay. So we came in, reviewed the lay of the land so we can be prepared to greet people and present evidence. And within 2.5 hours, you got this threatening email from the chief of staff complaining about your personal attorneys in a public courthouse.
Yes.
Okay. I'm going to start where Mr. Harris left off. He's making a big point. You signed Anthony's subpoena. You remember that, don't you?
Yes.
And he signed your subpoena, right?
Yes.
And he signed all of the subpoenas, right?
Yes.
All right, let's unpack that. Who is the only official, as it relates to personnel matters, that has the power to issue a subpoena?
The Director of Personnel.
Director of Personnel. Can the commission issue a subpoena?
No.
Can the commission sign a subpoena?
No.
Can counsel for the city sign a subpoena?
No.
Can Mr. Garvin sign a subpoena?
No.
Can Mr. Jared Boyd sign a subpoena?
No.
So you're the only one who could have signed that subpoena. Isn't that right?
Yes.
And you could have said, they're coming after me, I ain't doing a darn thing. You could have done that, couldn't you?
Yes.
Could have threw a monkey wrench in the process, couldn't you?
Yes.
Would have had to force them to go into court and get a quo warranto proceeding making you sign subpoenas, right?
Yes.
They could have done all of that.
Yes.
You could have done all of that.
Yes.
But you didn't.
No, I didn't.
Why?
Because in my role as secretary, I'm obligated to carry out the duties of that responsibility regardless of anything that's going on or even if it impacts me.
And how long has Anthony served in that role? Does it have anything to do with this matter?
No.
How long has Anthony served in the role as secretary to this commission?
About almost a year. About
Okay.
10 months, 10, 11 months.
So how many subpoenas you think you signed over that year of time with your delegation?
Primarily, I signed them all.
Okay.
I signed
Okay.
them all.
All right, but in this case, you stayed away from it,
Yes.
delegated to him to sign those subpoenas.
Yes.
Why?
Because I believe that it would be a conflict of interest for me to sign the subpoenas in my capacity because the hearing was against me.
Okay, fair enough. Let's talk about your training.
Okay.
And you talked about the training or the lack thereof. Could you elaborate on that facet? I mean, in other words, have you had any training on the city vehicle policy?
No.
You know why?
No.
Okay. And I believe earlier you testified that you would begin the process of implementing training, right?
Yes.
Why? Well, let me back up. Let me withdraw that question. What kind of training did you implement as it relates to your duties and responsibilities as Director of Personnel?
My duties and responsibilities as Director of Personnel, I pretty much became trained through my deputy directors and Dr. Byrd. That was the only training with regards to the city and as it relates to the Director of Personnel or any cabinet position that existed. The mayor's office within the last 9 to 10 months have instituted cabinet training that takes place once a month for different types of topics. But there is not now, nor has there ever been an onboarding or orientation for new cabinet members coming on board, nor for the Director of Personnel that comes on board.
Okay. And this policy, I think we referred to the letter. We're going to talk more about that letter. But in the letter from Mr. Boyd, he says that this vehicle use policy is publicly available.
Mm-hmm.
So if the public wanted to find that personnel vehicle use policy, if the media wanted to find that vehicle use policy, how would they go about finding it?
You would have to go to the city's career site, and you would have to know the policy name and put it in to have the site search for that particular policy. There is no place that you can go to and find all city policies in one location.
Well, how many different locations would these city policies be in?
Oh, potentially hundreds of spaces. No policy is in one singular location that you can go to, other than the civil service rules, the charter, and administrative regulations.
Okay, but these other policies, like the vehicle use policy, you would have to hunt for it.
Yes, you would.
And if you didn't plug in the right search term, what would happen?
You would not receive it. You would not get it.
You would not get it. So when's the first time you got it? How you get it?
I received it on August the 16th as a result of me calling the comptroller's office and requesting if a policy existed, and I was told yes, and then that policy was sent to me.
So that's the first time you saw the vehicle use policy?
Yes.
All right. Let's talk about this other policy, the policy relating to parking, right? Where would that one be located?
It would have to be on the city's site somewhere. And I think what I'm understanding now that I'm seeing this is that there is a travel policy.
And where is that? Where could, if I wanted to find that on my phone right now, how would I find it?
You would have to go to the City of St. Louis website,
Okay.
and then you would have to put in
Okay.
the search bar,
Okay.
St. Louis City travel policy.
Okay. What if I just say reimbursement policy? Would that come up under that?
No.
So I have to know the policy
Yes.
in order to find the policy that I don't know.
Yes.
Okay. Now, you went to Dr. Anthony Berg, as you've testified, because you were trying to figure out if you could get use of a city vehicle to make this run to retrieve some personal papers out of your car. Is that right?
Yes, it is.
All right. And there was some question about why you reached out to him. How long have you been working with Anthony?
A little over, close to 2 years.
Right. And I think you sort of testified. I don't want to put words in your mouth because I don't want to get an objection. But I'm just referencing something you said. You said 24/7. Could you explain to this tribunal and the free world what you meant by that?
Sure. Because of all the changes and the modernization that needed to take place in the city of St. Louis, within the Department of Personnel, it's not a 9-to-5 job. It's a transformation, it's a modernization effort. And so there are many of us in the department that work way beyond normal business hours. We work on Saturdays, we work on Sundays. We work 1, 2, 3 o'clock in the morning. It's not unheard of for us to be able to doing that level of work.
You get paid extra for that?
No, we do not.
Well, why would you do that? I mean, it's 5 o'clock. It's happy hour. I mean, why would you, after hours, wee hours in the morning, why would you do that?
Because that's what I was hired to do. I was hired by the mayor to come in and support her platform by transforming the Department of Personnel into a more modern department, and that's what I did, and that's what I committed to do, and that's what I'm still doing.
Okay. So this notion about punching a clock as it relates to you or Anthony, that's...
No.
Okay.
No punch a clock.
All right. And you don't get overtime for that time.
No.
All right. And well, let me ask you this. To your knowledge, does Anthony own the car?
No.
Okay, so how does he get around?
I don't know.
Okay. Did you come to understand that he uses those city vehicles quite a bit?
Yes.
And that's why you reached out to him, because do you understand he had a relationship with some of the people over there at the lot?
Yes.
Did he tell you that?
Yes.
And what did he say in that regard?
He pretty much said that, the manager of the municipal garage, they're friends, and that whenever he needs a car, it's not a problem for him to get one.
Okay. And that's why you reached out to him, right?
Yes.
To find out if, in fact, you could make this personal run to retrieve personal papers.
Yes.
And you knew that you all had a lot of business to take care of on the way.
Definitely, yes.
All right. So was it fair to say you were killing 2 birds with 1 stone?
Yes.
Because you could have went to Avis,
Yes.
right? You could have took the day off, right?
Yes.
It was the day before the holiday.
Yes.
You could have dropped every bit of city business and say, hey, I got a personal run. We'll see you after the holidays. You could have done that.
Yes.
But you didn't.
No, I didn't.
Why not?
because we were at a critical point with several projects, especially the FMLA project, in which we were trying to get finalized, and I had received several emails from Sarah Baker the day before and the day of, requesting status on policy and interpretation and language and those types of things. And I knew the urgency for Jared Boyd to want to get this new process out because it was creating risk for the city.
Okay, so you're in a dilemma now. You got a personal run you need to make, the holiday is coming up, and you got all of this business to take care of.
Yes.
And you could have went to Avis, and you could have took the day off and left it all, made your run, and dealt with it after the holidays. You could have done that.
Yes.
But you didn't,
No, I didn't.
all right? And let's talk about that run. You made that run with Anthony behind the wheel, right?
Yes.
Anthony went and checked out the policy, checked out the car, right?
Yes.
And you seen documentation. What reason did Anthony use for taking out the, I mean, what location did he put down?
He just put down city.
City. So he forgot the Jeff part.
Yes.
Did you tell him to do that?
No.
Did you know anything about that particular law?
No.
Okay. So for whatever reason, he on his own decided to say city, right?
Yes.
Not Jeff City.
Right.
Even though in these both sets of text messaging has the fact that you're going to Jeff City, right?
Right.
Okay. And so, but he decided to just say city
Yes.
for whatever reason.
Yes.
Okay. And so now you all are driving. He probably, what time he got there? Around 10-ish?
Closer to 10:30. Closer to 10:15, 10:30ish, I think.
Take a look at, let's use Anthony's. That is 6A. Take a look at that.
6A in,
In the other binder, I'm sorry. We got a lot of binding.
6A. Okay.
All right. And these are some text messages from Anthony, right?
Yes.
Are these complete?
No.
What's missing?
The text message where I told Anthony that the trip was not completely for city business, that it was personal.
Okay. Take a look. Any others?
No.
Do you know why in these emails that were provided to assume somebody in the city, why he omitted that particular email that said you were going to Jeff City? You know why somehow that dropped off the email or text string?
No.
Okay. But it says, if you look at the last entry, what does that last entry say?
And specifically on which exhibit?
I'm sorry, this is the government's exhibit.
Appointing authorities, yeah.
The pointing, I'm sorry, the pointing authority exhibit 6A, page, it's the last page, it's got a two-sided paper, it's the last page of the text messages. 6A of the appointing authority. Okay? Now, what is the last entry on there, and who is that from?
Anthony.
And what does
Dr.
Anthony
Bird,
say?
that he's here.
Okay, and what time does it indicate that he was here?
10:51 a.m.
10:51 a.m. Okay, so you couldn't have left before 10:51 a.m., right?
Correct.
All right. So we're now at 10:51, right? Mm-hmm. And you took care of business at home.
Yes.
Do you, a lot of times, take care of business at home?
Oh, definitely, yes.
And is there a policy that says, don't do city business on private, personal property?
No.
Any policy like that floating around?
No.
Okay. And if it did, we'd have a stack of charges over here, wouldn't we?
Yes, we would.
Okay. and you worked for the city, give us an example of you're an early riser, I understand?
Yes, I am.
And when you rise, how early are you working for the city?
I'm normally up by 4 a.m. in the morning sending emails, text messages. My team gets on me all the time. I learned how to schedule it to send it at 8 a.m. because they would start responding back to me at 4 and 5 o'clock in the morning. So it's not unheard of that I'm up working at 4 a.m.
Well, not only is it not unheard of, it's fairly routine, isn't it?
Yes,
Because you're an early riser.
yes.
And you are committed, well, I don't put words in your mouth. Are you committed to do that for this great city of ours?
Yes, I am.
Why?
Because I believe in the work. Number one, I have the qualifications and the skills to do the work that needs to be done in order to transform the Department of Personnel. The other is because I believe in the civil service system. I believe in our employees. I believe in our appointing authorities. And I believe that Department of Personnel is the heart of what gets this work done and what sets the tone for the rest of the city.
Dedicated public service.
Yes.
Give us, if we could, your educational background.
I have a Bachelor of Arts degree in journalism. I have 20 hours towards a Master's of Law from Cornell. I have several certifications in HR management throughout my career.
Okay, let me hand you, if I could, hand you Respondents Exhibit 7. You have it, Brian? You got it. Oh, sure. Yeah. Any objection? What's the relevance? I'm going through her professional background with respect to this position that she holds that the mayor of St. Louis has seen fit to try to terminate her.
Does it relate to the conduct, the malfeasance? Does it relate
Yeah, absolutely.
Okay.
It relates. I'm going to show you.
If her qualifications on there relate to her violating the city policy, go for it.
Okay, thank you. Let me hand you what's been marked, just to save some time, because we're trying to get through this. And the resume, just for the record, this is the resume of the director. That's 4 pages long. Okay, and I'm not going to read it all, because I know people want to leave and do some stuff, and I know the commission wants to move this thing along. But I just want to touch on some of the highlights, right? Highlights. St. Louis City, Director of Personnel 2022 to present. CARE STL Health 2018-2022. Betty Jean Kerr Health Centers 2017-2018. Davis Medical Holdings in Atlanta, Georgia 2014 to 2017. CHEP, what is CHEP? CHEP.
Yes, CHEP is a logistical containers manufacturing organization that is global.
Okay, and that was in Atlanta, Georgia from 2012 to 2014, right?
Yes.
And then you got a little short summary here, because I guess we could add 8 more pages, but looks like you work with the Washington Nationals Baseball Club.
Yes.
What'd you do for the Washington Nationals Baseball Club in Washington, D.C.?
I was their vice president of human resources.
Okay, Vice President of Human Resources. And then you were at the Washington Times LLC in Washington, D.C. What is the Washington Times?
The Washington Times LLC is a media company. At that particular time, it was a print organization, and I was there to transform it from print to digital.
Okay. And then General Dynamics, global Vice President of Human Resources, 2003 to 2007.
Yes.
Is that right? What is General Dynamics?
General Dynamics is pretty much they have different arms, but I was with the armor division of General Dynamics, and we were responsible for military contracts during Desert Storm.
Okay. Honeywell, South Carolina, 1998 to 2000, manager of human resources. Tell us about that. What's Honeywell?
Yes.
What's Honeywell?
Honeywell is a manufacturing organization responsible for,
I'm on the
oh
last
gosh,
one. I'm on the last one.
Okay.
a number.
We can stipulate to the.
A number of different products. The division that I was in was more around the heating and energy, and I was responsible for the startup of an organization in India, Gurgaon, India, as well as the facility.
Where in India? I'm sorry. Where?
Gurgaon.
Gorgon? What the heck is Gorgon?
It's in India.
Somewhere in India. Okay, I'm sorry.
Okay,
I
it's
cut
in
you off.
India. And also a plant in Conway, South Carolina.
Okay, and lastly, Fujifilm, manager of human resources from 1994 to 1998. What is Fujifilm?
Fujifilm, they produce film, graphic plates, one-stop cameras, a number of different film types of products, and I was hired there to start up 2 of their manufacturing operations in Blythewood, South Carolina,
Okay.
and also in Greenwood.
Okay. Now, you talked about it, but let's unpack it a little bit. You started, after all of this worldwide experience, global HR, you decided to take a job at City of St. Louis. It's not Gorgon, but we like it still, right? And you decided to take a job working for the City of St. Louis. Why did you take that job?
Because I love my city. Because I love being here, and I believe that with all of my knowledge and all of my experience, that I could add value to the city. That's pretty much the primary reason. I could have had other opportunities that would have caused me to leave St. Louis, but I chose to want to be here.
And took the job.
Yes.
Now, who did you interview with to get that job?
I interviewed initially with Collaborative Strategies, which was a retained search firm that the city had hired to help them fill the Director of Personnel position.
And who did you talk to in the city?
In the city, I met with the Civil Service Commission.
Which civil service commissioners in particular?
Chairperson Barney was a part of that team. Also, Betty Battle Turner was a part of that team. Dean Dybo was a part of that team, and also Sylvia Donaldson.
Okay. And so was that considered first base in terms of getting interviewed directly by the city outside of this outside outfit?
I'm sorry, repeat the question again.
Was that the first contact you had with city-related personnel related to the job?
No, it was not.
Okay, what other contact you had before you met with these honorable commissioners, or at least one of the 2 honorable commissioners?
I had been courted prior by the search firm to apply for the position. And I chose not to apply for the position because of concerns that I had.
What were those concerns?
I had concerns because of the relationship that my husband had that oftentimes is adversarial with the administration.
Why did that cause you concern?
Because I didn't believe that I would be given a fair chance possibly for the position because of that relationship that was off and on.
Okay, but ultimately you were given a fair chance.
Ultimately, I was given a fair. I did speak with. I called Chief of Staff Jared Boyd. Chief of Staff Jared Boyd before I officially applied.
Okay, and you got the job.
Yes.
And were you interviewed by Mayor Tashara Jones?
Yes, I was.
Tell us about that interview.
I had an initial interview with Mayor Jones, and it went well. I was asked to come back for a final interview with Mayor Jones and with Nancy Cross.
Just for the record, who's Nancy Cross?
Nancy Cross is the Executive Director of Operations for the City of St. Louis.
Okay, 2 interviews, a second interview, ultimately?
Yes.
All right. And during that interview, did the subject of your husband come up?
Yes, it did.
Tell us about that.
During the interview with Mayor Jones and with Ms. Cross, Director Cross, they wanted to meet with me because they had some concerns that they wanted to discuss with me. During the meeting, I said pretty much, I said, let's just talk about the elephant in the room. Are you speaking about my husband?
Now, hold on, let's back up a minute. Who brought up the subject of your husband?
I did.
Okay, so right off the bat, you knew that,
Yes.
based on what you understood to be his involvement.
Yes.
Let's talk a little bit about your husband. What does he do?
My husband is a clergyman. He is a pastor here in St. Louis for the Greater Fairfax Missionary Baptist Church. In addition to that, he is the social justice chairperson for the Clergy Coalition with here in St. Louis. He is also the social justice director general for the Progressive National Baptist Convention. He is the known activist that is here in the city of St. Louis. He is also the chairperson for the Detention Oversight Board, Yeah.
Okay, and is he also a plaintiff in a lawsuit against the city?
Yes, he is.
Tell us about that.
My husband is currently a plaintiff in a lawsuit against the city that has been in place since 2017 as a result of alleged, because it has not been finalized or anything like that, it alleged that he was beat up by the police during the Stockley verdict.
Okay. All right. Now, you talked about relying on Anthony Berlin. You said, why do you rely on your staff?
Because they have the most experience with the city government, with the ordinances, the charter, legislations, policies, those types of things. And I had support from the mayor's office, as communicated to me on several occasions, to depend on my staff, because there was nobody else here that, pretty much could train me. And so I began to rely on them for those things that I did not know. And as I began to learn things, I was able to make decisions independent of them once I understood what the policies actually meant, where they were, and, those types of things.
Okay, so let's go back to that elephant in room 200. What was communicated during that session?
What was communicated during that session is that I told Director Cross and I told the mayor that they did not need to be concerned about my husband, that I am able to do my job independent of him, and that other things that they may have heard were not true, and that they did not need to be concerned, that I would be able to operate independent of him.
Okay, and are you and she in the same sorority?
The mayor and I are in the same sorority, yes.
Okay. And some kind of sisterhood bond, is that what the sorority is all about?
Yes.
Okay. All right. And I won't ask you which sorority, but I do see you have red on, so I don't have to say anything further. Now, since you've joined the city, have you made improvements in that Department of Personnel?
Yes.
And let's put it in context. You started, when was your first date of employment?
November 7th, 2022.
All right, November 7th, 2022.
Yes.
You started,
Yes.
first time in city government,
Yes.
wanting to help lift this city up, right?
Yes.
Wanting to modernize this city's HR functions.
Yes.
When you got in there that first day, from a modernization standpoint, what did you see?
Well, I walked into a department that was still using typewriters.
What's that? What's the typewriter? I withdraw that question. Continue, Director. I'm sorry.
I walked into a system that I believe, and let me preface this by saying that this is no way a criticism of my team.
Right.
They operated with what they had to operate with and under the rules that have been given and provided to them.
And
So-
one of those tools was a thing they call a typewriter?
Yes.
Okay. All right. Continue.
I walked into a recruitment system that was somewhat archaic from a standpoint of being able to provide candidates in a timely manner. And that was one of the criticisms that the mayor would receive on a regular basis, that we weren't able to fill positions quickly. This system had two different systems. One was a access database, and the other one was an on-site online career site, and team members would have to print off applications and then hand type them into this other access database, and so this entire area or section pretty much needed to be revamped, as an example.
Well, give me some more examples.
Oh, sure.
Let me just object to this line. I mean, we had an objection earlier about, prior work records, and they went on, and they didn't want to get into that. And now I guess we're going to go through, like, her work history and what she's done. I mean, if it's not relevant on direct, I assume it's not relevant on cross.
And let me explain why this is relevant. Let me explain why this is highly relevant. And the reason it's relevant is because of this. Right? This is why it's relevant, because this is why she's being terminated.
Well, just to be clear for the record, you're holding up a plastic bag that appears to have some U.S. currency in it?
Well, to be more precise, Your
And
Honor,
change?
To be more precise, Your Honor, there is a total of 3 50s, 120, 2 nickels, 1 dime, and 10 pennies. Okay? And so this is why we're here. Our view of the world, as distorted as might be, is really along the lines of, as the court knows, res ipsa. The thing speaks for itself. And the question in my mind, and should be in your mind as the decision makers and everybody's mind in the free world, is why, with a resume like this, with the type of innovation she brought in, would we be here paying Stinson thousands and thousands of dollars for 3 50s, 120, 2 nickels, 1 dime, and 10 pennies?
And we're trying to tell this commission and the public why we're here.
And I'm trying to tell the commission why we're here.
I mean, I don't mind if you can go on and get into her work history, but I think that the appointing authority needs the same opportunity to get into the details of why we are here.
Oh, bring her. I think there's an article in the Day's Business Journal. I want to talk to her about that. Absolutely.
All right,
So-
gentlemen, both of you are engaging in a little colloquy between yourself, but the question that you're asking your witness is what we're here for, okay? You've
Okay.
got her resume, you've gone through it with her.
Okay.
What's the next question or topic
Okay.
that you're going to get into?
Exhibit respondents, exhibit 2, honorable commissioners, and your honor. Could you find the other binder, my binder? I'm sorry, mine, I think, yeah, that's our binder. The one without the cover was there. Okay, turn to tab 2.
St. Louis Department of Personnel Annual Report?
Yes.
All right.
Same objection that it's totally irrelevant to the issue here.
Okay.
This shows the vast improvements that she has made in this department. Hold on, don't put up yet. We don't have a jury, but anyway. The vast improvements she's made over the course of 2.5 years. This is part of what you all have to consider when you say, okay, malfeasance, $170, when we have this benefit to taxpayers. Our theory is a simple theory. As the court knows, there's a doctrine called res ipsa loquitur. The thing speaks for itself. And we submit that these things that we're offering, because we should be entitled to present our defense. And our defense is that we have the most talented, the most experienced, the most innovative director of personnel, in my humble opinion, in the history of the city of St. Louis. Yet, here we are.
Mr. Norwood, that would be a part of your closing argument.
No, I'm
But
saying.
that is not
No.
an explanation. Now, you said this is going to show the work she's done.
The
Okay,
innovations, yes.
as far as that might be, that might relate to her work history. Let's hear a specific question if
Okay.
you're going to ask about some specific thing that she's done that you want to point out.
Yes, I'm not going to read the whole thing.
I would pray.
Okay, but I'd like to move for the admission of Respondents Exhibit 2.
Well, the entire document is obviously looks like, on its face, a city document, the annual report for 2023 and 2024 of the City of St. Louis Department of Personnel. The commission, I think, can take it for what it's worth, so
Yes.
I
I have no objection. to
no
the
objection,
admission.
it's admitted into
In
evidence.
fact, we stipulate what's in the report.
Okay.
Okay,
So,
so it's admitted,
it's,
and
right.
let me direct the director's attention to page 4. Page 4 of the document. Page 4 of the document. What we do. There's a statement from a Wilford Pickney, Director, Office of Violence Prevention. You see that?
On page 4, are you asking the witness?
Yes.
Okay.
Yes.
And I'm just going to read the first line. It says, communication with the Director of Personnel staff improved during my tenure as Director. You see that? Okay. Let's go to the next page, page 5. Who is April Griffin?
The Director of Affordable Housing.
Is she under your domain?
No.
That's a separate city department.
Yes.
And she says, quote, the responsiveness and professionalism demonstrated by you and your staff during my department's most challenging year have been invaluable. Invaluable. Under your leadership, the Department of Personnel has listened to our concerns, and your team has risen to the challenge and delivered exceptional performance. Right? That's what April Griffin wrote, right?
Yes.
Okay. And I'm not going to get into the weeds on everything, but there are some pretty significant data on some of the improvements. I just want to touch on a couple of those in the interest of time as to what types of improvements, innovations you've made. Just give me the top 3, and then we could move. Well, I got a couple just small points, and then we'll move on. But in terms of improvements, what kind of systems have you put in place?
We have since implemented Taleo, which is a applicant tracking system that allows the Department of Personnel now to no longer have to manually type in applications. It's all in a cloud-based system.
You still have typewriters?
No, we do not.
No more typewriters?
No more typewriters.
Whatever that is.
Yes.
Okay. Continue.
We have improved with regards to the number of hires that we've been able to make and how quickly that we're able to provide eligible candidates to appointing authorities. The increase in that specifically, it says that starting with 455 employees in 2022, the department increased its workforce by 34.7% to reach 610 employees in 2023, and then building on that success in 2024, reaching 727 employees. This represents a significant 59.78% increase in staffing levels from 2022 to 2024.
Okay. And this document, just for the record, is about 24 pages. Is that right?
Yes.
All right. Who is Ed Ware? Ed Ware.
Ed Ware is the appointing authority, the director for the Buildings Division.
All right. And he said, quote, the Department of Personnel support with UKG time and attendance. What is that?
UKG time and attendance, it is a new platform that the city has implemented that has now made our payroll processing as well as personnel actions pretty much all digital.
When you say the city's implemented, who led that charge?
It was a combination of a number of different departments that led the charge, to include the IT department. It also included the Department of Personnel, was very, very key in this process, and it also included the Comptroller's Office, who was instrumental as well in the implementation of this system.
And it says, support with UKG time, as well as access to candidates' applications and requisitions to Taleo, that's what you referenced
Yes.
earlier, right? Has been a significant improvement, in my opinion. Additionally, the DOP staff, DOP is Department of Personnel,
Yes.
has always been great to work with. I truly appreciate their guidance and expertise. Right? That's what
Yes.
the Commissioner of Building, is he under your domain?
No, he's under the Department of Public Safety.
All right. And I don't want to go through all of them, it's in the record, but let me go to one last one on page 24. And Dale Jones, it looks like, who is she?
Dale Jones is a tenured employee with the Department of Personnel, and she is currently the Employee Experience Manager responsible for orientation, onboarding, and retention. And prior to that, she was the Training and Development Manager.
Okay, and let's just take a look at what she says. She says, as the Employee Experience Manager, I am proud to recognize the impactful initiatives being implemented under the leadership of Director Sonia Jenkins Gray in our Department of Personnel. Her commitment to enhancing employee engagement and onboarding processes have set a new standard for our city workforce. This year, Director Jenkins Gray introduced the 30, 60, 90-day check-in program, a pioneering effort designed to support employees comprehensively as they integrate into their roles. These structured check-ins ensure employees not only meet expectations, but also feel supported throughout their introductory period. These programs are a testament to our department's dedication to nurturing and developing talent within the city. We are excited about the positive impact these changes will have on employees and appreciate Director Jenkins Gray's visionary leadership. Together, we are building a stronger, more connected workforce. You see that?
Yes.
Was this a paid political endorsement?
No.
Did you bribe her to write that?
No.
She's in your department, right?
Yes.
Did you promise to give her a promotion for writing that?
No.
Okay.
She was somebody that actually had filed a complaint against me.
I'm sorry?
I'm sorry.
You
No,
gotta
I was
speak up.
just, yes, I was just saying, actually, I was very shocked by this testimonial of Dale Jones, because Dale Jones is someone who had filed a claim of malfeasance against me with the commission.
Okay. Wait. Hold, stop the presses. Let me unpack that.
Okay.
A person in your department who lodged a complaint against you that was processed through this commission wrote that these programs, that she's excited about the positive impact and she appreciates your leadership. She may think you're a malfeasor, but she appreciates your leadership, is what she wrote.
Yes.
Your Honor, I'm going to object. I mean,
I withdraw the question. I withdraw the question. I'm sorry, Councilman. I'm over the top. Sorry.
Move on then.
My bad. All right. Do you know if Mr. Jarrett or Sarah Baker took any of this into account when they hauled you into his office and dropped this notice of termination on their desk?
No.
Did they ask you about these improvements?
No.
Did they ask you to provide testimonials of people you work with who could testify to your character, your fitness, your innovation, your vision? Did any of that come up in that meeting?
No.
Do you know why?
No.
I would think that if the mayor, our executive leader, who has a duty to the taxpayers to encourage innovation, that she would want to know what she's throwing out the window for 350s, 120, 2 nickels, a dime, and 10 pennies. Don't you think she would want to know that?
I would think so, yes.
You would think Mr. Boyd would want to know that?
Yes.
But they never came up.
No.
Well, let's talk about that. Let's go into that meeting room.
Yes.
Why did you think you were there?
I did not know why I was there, but from Jared and Sarah's perspective, but for me, I was there to self-disclose and tell them about my violation of the vehicle use policy.
And why were you self-disclosing? Ratting on yourself, essentially. Well, it was already out there, but you went in and you tell me in your own, you tell the commission in your own words, why did you do this?
Because once I found out that I had violated policy, I have always been transparent and honest with the administration, and I do that every day within my job. I needed to tell them that I did something wrong.
Did that bother you that you had done something
Yes,
wrong?
it did.
Why?
Because I strive not to violate policies or do anything wrong, because I know of the importance, especially of my role, following the rules. And when I found out that I broke a rule, I went to tell that I had broke a rule.
Okay. Now let's walk the commissioners, the judge, the audience into, break it down. You walked, I mean, how'd you get there? You walked over to whose office?
I walked over to Mayor Jones's office.
Okay.
Yes.
All right. And when you say Mayor Jones's office, are there offices within
Yes.
the chambers? And does Mr. Boyd have an office there?
Yes.
And Mr. Boyd, just for the record, he's the chief of staff, right?
Correct.
And then Sarah Baker was there. Who is Sarah Baker?
Sarah Baker reports to Jared Boyd, and she is the deputy. She's the deputy chief of staff.
And we are in whose office?
Jared Boyd.
Was he in the office when you arrived at the office?
I don't recall. Sarah came out to greet me and to bring me back, and I can't recall if Jared was already in the office or not.
Is Sarah in the room?
Yes, she is.
Where is she? Could you point her out for me?
She's sitting in the back of the room on the left-hand side.
Okay. And what did Sarah say to you?
She pretty much said, let's cut through the chase, and then she shared the reason that I was there.
Okay, during that session, did the issue come up regarding the prior director of personnel?
That came up in my second meeting with them when I didn't know it was a pre-termination conversation, but in that meeting, the prior director did come up.
And when was that meeting in conjunction with this meeting?
That meeting was on August the 19th, on August 21st.
Okay. And let's go to that meeting. I'm going to jump around a little bit, but I want to focus on that particular meeting where the issue of Rick Frank, who was the prior director of personnel before you, came up. Tell us about that.
Yes.
And tell the commission, because they're interested in hearing,
Okay.
I think.
We started the meeting, and before we got into the conversation with regards to the apparent pre-termination conversation, Sarah Baker asked me, did I have a reemployment letter for Richard Frank, who's the previous director of personnel.
Okay, let's just pause right there. What's a reemployment letter for those of us who don't know?
Yes. A reemployment letter is where an employee that has left the city in good standing has a 2-year window in which they can reapply for the position that they left with approval from the director of personnel.
And is that a civil service right?
Yes.
Okay. All right. So she brought up the issue of Rick Frank's reemployment letter at a time when they're discussing ways to terminate you, is that right?
That is correct.
What exactly did she say about Mr. Rick Frank and the reemployment letter?
Yes, she asked me, did I have a reemployment letter for Richard Frank? And I said yes. And she asked me, where was it? And I didn't recall at that time because that wasn't something that was at the forefront of my mind. And then she said, I'm going to tell you what position to put him on the reemployment list for.
And
And
what position did she tell you?
She didn't tell me at that particular time what position it would be. She just wanted it to emphatically let me know not to place him on the director of personnel list, that she would tell me what list to put him on.
What was your reaction to that?
I didn't have one. I was just stunned and shocked.
Why?
I was stunned and shocked because the mayor's office should not be involving themselves with decisions of the director of personnel of where to place people on reemployment lists.
Why?
Because it's driven by the charter. That is not supposed to happen. That's considered political interference.
And so that would be a violation of the charter.
Yeah, it would be a violation of the charter.
Coming in there and tell you to not place someone who has served this city and the director of personnel, telling you not to put them in the queue
That he applied for.
that he applied for, which was what?
Director of personnel.
Okay. So if you had resigned, and I think you were asked in one of those meetings to resign by Mr. Boyd, right?
Yes.
And if you had resigned, he would have been the one that would be the top candidate to replace you.
He would be on a list.
List.
That in which the mayor would have to give consideration to him for the position once it became vacant.
And that, I mean, he had an inside straight because he had been in the system for how long?
18 years.
18 years. So he was set up. And the mayor could have chosen him, maybe, or other candidates, right?
There was, well, no, at that particular time, there was no other list. There was no eligible list for the director of personnel position. So Rick Frank would have been the only one on the list.
And he would have been back in that chair
Yes.
if you had resigned that day.
Potentially, yes.
Okay. When you say potentially, what do you mean?
I'm thinking through the process. So yes, he would have been back in the chair.
Okay.
Unless the mayor chose not to select him.
All right. And so we have Sarah Baker telling you right before she's dropping bomb number 2 who or where he should go.
Yes.
And where did she say he should go? She didn't say.
She didn't say.
But she said stay tuned. Was that your understanding?
Yes.
That she would come back and tell you, forget the letter, right?
No, not to forget the letter, but based off of the letter, where to place him on, to what position to put him on a reemployment list for.
So how does that work? I'm just trying to understand, because the charter rules say that he's on this list, that's the position he asked for. How do you do that? How do you take somebody who wants position A and ship them to Siberia somewhere for position B?
I want to object to this line of questioning. I mean, I've let it go on, but I don't understand the relevance of this to the issue that the commission has to decide.
Our defense is political interference in personnel. That's
not defense.
Well, in your view of the world.
I mean, there's case law.
Well, no, your case law is all wet.
No.
So let's
Gentlemen.
let me say this, because I'm going to tell you case law. The case law, the charter. Interesting. I've dealt with employment matters for decades. Spent 2 years in federal court with Judge Wright deciding employment cases. And the city has a unique anti-discrimination law. And that anti-discrimination law prohibits race, sex, all that stuff, but it also prohibits political discrimination, terminating employees for expressing political views. I'd never seen that before, but it's there in black and white. And our view of the world, as wet as it might be, is that this is classic. It's a hostile takeover of the civil service system, your system. And we're going to have, I want to talk to the mayor, I'd love to talk to the mayor, but that's our case. And it says, the charter goes further. further and says, if you with counsel from the judge, find that this thing is driven by politics, you have an obligation, even if she was out there on the street, even if she had already been kicked down the road, you have an obligation to reinstate her and pay her. That's what the charter says. That's not Ron Norwood. He's a bright dude, but I wasn't around when they created that charter. Okay, that's what the charter says, counsel.
So the law is that even if it were the case that there was some political motivation for, an employment action, which there was not, but even if that were the case, the issue before the commission is whether or not the director engaged in malfeasance as it states in the chart. That's the issue.
All right, well, gentlemen, I expect that both of you will probably address this issue that you're talking about now. You have two diametrically opposed positions as to whether anything about political interference is relevant here or not. I expect you're going to be addressing that in the briefs that you will be filing, that you're given under the rules 2 weeks after the conclusion of the hearing to file those.
Yes.
So I expect you'll be addressing those. Now, for right now, the question is what can be asked about or not, and I thought what we were asking about was the work record. Now, you want to ask about political interference?
Yes, absolutely.
All right. I'm just going to have to hear what the question is. I believe that it is relevant from the standpoint of how any decision was made as to whether, in fact, a decision to terminate the employee was motivated or not. The charter does have provisions about that, does it not?
The charter, whatever the charter says about political interference has to do with, let's say one administration comes in, like who are all Democrats, and their previous administration was Republican, then you can't just come in and say, all Republicans are out, and now it's only going to be Democrats. That's what that's about. It's not about all these, vague allegations and unsubstantiated claims that someone is politically against another person. And again, this is totally irrelevant to the issue, and the law says that even if there was some, even some modicum of political motivation, as long as the evidence supports the fact that there was malfeasance that was committed, that's all that counts.
All right. I understand your objection, but I think for efficiency purposes, I'm going to overrule your objection and allow some questions into this. So let's, however, try to be precise and to the point.
Yes.
Okay.
I'm just asking her what happened in that setting.
Well, that would be precise about a particular date and time.
Okay.
Go ahead.
Particular date and time. What date and time?
It was August 21st.
Okay. And for the commission, what did Sarah Baker say?
Before we began, I did not know what the meeting was for. I had no idea that they were looking to terminate me. And so Sarah Baker started the conversation out by asking me, do I have a pre-termination letter for Richard Frank? In which I said yes. And she asked me where was the letter. And I said, I don't know exactly, but I knew it was in my office someplace. And I'm paraphrasing right now because I cannot remember that exact word. She then said that she was going to tell me what position to place him on a list for based off of his reemployment, based off of his reemployment letter. She
misspoke. I think you misspoke. You said pre-termination letter. I think you were talking about that reapplication letter.
Oh, no. Oh, okay, let me go back. I may have misspoke. I'm sorry. I did not realize that I was there to discuss termination of employment. And when we sat down to begin the meeting, Sarah Baker asked me, did I have a reemployment letter from Richard Frank, who is my predecessor? I responded by saying yes. She asked me, had he been placed on the reemployment list for Director of Personnel? I said, no, I have not done anything with the letter. And then she proceeded to tell me that she will tell me what position to place his reemployment letter on, to imply, do not place him on the Director of Personnel. I will tell you what position to use. Within the Civil Service Rule for Reemployment, the discretion is left up to the Director of Personnel what position that he or she can place an employee on, but it has to be relevant to the position that they applied for. Rick Frank applied for the Director of Personnel. Therefore, I could only put him on the Director of Personnel position or maybe a Deputy Director position. I could not place him on any other position. So Sarah's request shocked me, number one, because the mayor's office should not be directing the Director of Personnel of what list to place somebody on. And then in addition to that, it was just kind of weird. That's not something that should happen or should occur.
Is Sarah Baker your appointing authority?
No, she is not.
So you know where she got the authority to tell you to violate the city charter?
No, I don't.
Have you seen any delegation of authority from the mayor saying, Sarah Baker, I am delegating you authority to violate the city charter? Have you seen any delegation of authority like that?
No.
Let's look at the delegation of authority we have seen. Go to the naked binder, the one without the cover page, and go to tab 11. The other one. Well, yeah, there you go. Tab 11.
Tab 11.
From the binder from the appointing authority. Okay. When's the first time you saw that?
Today.
Okay. And what is this document? You've seen this form of document before, haven't you?
Yes.
What is it?
It is a document in which the appointing authority delegates his or her authority to someone else to perform actions on their behalf.
Okay. And what does this purport to be?
This looks to be a delegation of authority that the mayor has given to Jared Boyd and also to Nancy Cross.
Okay. Where does Sarah Baker fit in on there?
She doesn't.
Okay. So Sarah Baker directing you what to do in violation of the charter based on some delegation authority that we haven't seen, right?
Right.
All right. But the delegation of authority we do see is one that refers to L. Jared Boyd and Nancy Cross, right?
Yes.
Chief of Staff and Executive Director of Operations, right?
Yes.
And their signatures are on there, right?
Yes.
And it looks like there's some form of signature for Mayor Tashara O. Jones, right?
Yes.
All right. And per this document, she is delegating to Mr. Boyd and Miss Nancy Cross the authority to handle, quote, all personnel actions.
Yes.
You see that?
Yes.
And what's the date of this document?
August 23rd, 2024.
Okay, was this before or after the meeting you had with them?
After
What was after, the meeting or the document?
the document.
Okay, so you met with them twice
Yes.
before this delegation of authority, right?
Yes.
And you understood that they had conducted a full-fledged investigation,
Yes.
right? And that investigation manifested into a letter they gave to you, right?
Yes.
They did all of that before the authority was delegated to them to do all of that.
That's correct.
Is that proper?
No.
Why not?
Because the delegation of authority form, or the delegation of appointing authorities responsibilities must be documented and approved and signed off on before that delegation of authority is given.
Before?
Yes.
Well, why can't you do it afterwards? I mean, what's the big deal? It's only a couple days.
Because it's in violation. That authority remains with the appointing authority until such time that it is signed off on and approved by that appointing authority and received by those that the authority is being delegated to.
So when they met with you, Mr. Boyd, he didn't have the authority.
No, he did not.
And when Nancy Cross met with you, she didn't have the authority.
No, she did not.
And as far as we can tell from the documents the city produced, she never got that authority.
No, she did not.
Okay. Fair enough. And do you know why? Well, let me ask this. Prior to August 23rd, 2024, do you know why the mayor hadn't delegated that authority to Jared Boyd before your situation came up?
No.
Somehow, on this day, in 2020, the day of our Lord, August 23rd, 2024, after the investigation, after they decided you were toast, after Mr. Boyd asked for your resignation, the mayor signed a delegation of authority with respect to that activity.
Yes.
And that was illegal, right?
As far as I'm concerned, yes.
Violations, right?
Violations, yes.
Because the only person, your appointing authority at that point was the only person who had the authority to investigate you, to browbeat you, to threaten you with moving Rick off the employment list, even though it would be a violation of charter, but we'll push that to the side. She was the only one who had the authority at the time they interviewed you.
Yes.
And at the time they interviewed Anthony.
Yes.
And at the time they interviewed all of these witnesses.
Yes.
Under the guise of having the authority in writing for the mayor to do it.
Yes.
Can we have a recess? Our bathroom?
For how long?
break? Just enough
5
to me
minutes, all
to
right.
walk in the
It's
urinal.
quarter to 4, so we'll go to 10 to 4.
Thank you, Your Honor.
5 minutes has passed. The witness is back in her chair. Ms. Norwood, you can ask a question in your examination.
Yes, thank you, Your Honor. Could you turn, this is in the appointing authorities binder, exhibit, I think it's 6B. You see that?
Yes.
This is the first time you saw that.
At the deposition
Which deposition?
for Dr. Anthony Byrd.
Okay. And Exhibit B, for the record, appears to be a municipal garage motor pool experience record, and this is in the appointing authorities Exhibit 6B. And you saw that for the first time in Dr. Byrd's deposition, correct?
Yes.
All right. And so we talked about this, but it looks like the vehicle was checked out on 7/3/24, correct? Correct?
Yeah. Yes.
That's the date, right?
Yes.
And what date was that? That was the day before the 4th of July, is that right?
Yes.
Was it a full day?
I believe it was an early release. Typically, the mayor will will shut the city down before a holiday, like at 2 or 3 o'clock. And even if she doesn't, I usually will, before a holiday, will let my team go.
Why? Are they cheating the city when you let them go early
No.
for the holiday weekend?
No.
Why not?
Because an appointing authority has that authority, just like the mayor has the authority to be able to release the entire city.
Okay. So now let's take a look at this thing. This is, it says it was timeout is 10 o'clock, right? The car?
Yes.
And expected return date, what's that expected return date?
7:10.
7/10/24, right?
Yes. Yes.
That's what, by my math, that's a week, right? Did you tell them you were going to spend a week in Jeff City?
No.
All right. And he knew it was going to be a round trip thing, right?
Yes,
Checked the vehicle out, right?
yes,
Kept it for a week. You see that?
yes.
And it looks like the return date, what's the return date?
July 10th, 2024,
Okay. At what time?
10:30 a.m.
Okay. And then they logged the mileage start time. Do you see that?
Yes,
And what's that mileage start time?
767 miles.
767 miles. And how far is Jefferson City away? How many miles?
120?
Okay, so let's err on the side of, let's say 250.
Okay.
All right, so if we add 250 onto 727, I'm not the best at math, but that's about 1,000 and change mileage, right?
Yes,
But when he returned, it was at 1488. You see that?
yes, okay,
So that's a couple of more trips to Jeff City, right?
yes.
Do you know if Mr. Jared Boyd and Ms. Sarah Baker, when they did their investigation and saw that discrepancy, 400-mile-an-hour discrepancy, when he was on holiday at that point, right?
Yes,
He was gone
yes,
with a city vehicle driving 488 miles? Did he go to a drag race? Did he drive all around the city? 400, that'll get me to Chicago.
Mr. Norwood, you're speculating. The witness either knows or does not know where Mr. Byrd drove, other than what she's described as when he was driving her. You can ask her that. If she
Okay.
doesn't have any personal knowledge,
I agree.
then she's not allowed to, and you're not allowed to speculate about it.
You're absolutely right, Your Honor, and I beg the court's the tribunal's forgiveness. The only point I have is the fact that we got 488 unaccounted for miles, right?
yes,
He wasn't on city business because he was on holiday.
right.
And the investigators, somehow, did they miss that one? I withdraw the question. But they want to terminate you.
Right.
Was there a time when you believed that you were engaged in what is referred to as a hostile work environment?
Yes.
Tell the commission about that.
From the beginning, when I was hired with the Department of Personnel, I received a great deal of resistance, constant, what I believe, harassment with regards to the work that I was trying to get accomplished within the Department of Personnel. There was a lot of gossip, a lot of innuendos, and to be quite honest, that has lasted the entire time that I've been with the City of St. Louis in my role as Director of Personnel. And I have made these instances aware to the mayor's office and to the city councilor's office of these incidents that would occur and that would happen.
And we went through your resume. You've served in a lot of companies in a lot of different capacities, all in the HR capacity. Have you ever, in all of those companies, experienced anything like this?
Never. Never.
Did it shock you?
Yes, it did.
Why?
It shocked me, first of all, because of the profession of human resources. And it is a profession that must be operated based off of truth, integrity, character, with regards to carrying out the work of a human resources professional. And so it was very wonky. It was very weird for me to experience this type of behavior in an HR department. It was a department that has a history of filing EEOC complaints, a history of filing anything that you could think of with regards to employment actions. And I had never experienced that before. It created a great deal of distress for me to have a HR department that behaved, that had these types of behavior issues. Yeah.
And you reported that to the mayor's office?
All the time. Every time a complaint came in against me, I told the mayor's office and the city councilor's office, every time.
And what did they do?
Nothing.
Nothing?
Nothing at all.
Okay, and the mayor's your appointing authority, right?
Yes.
And in 2.5 years, other than when she went around and ignored you at the Christmas event, have you had any sit-downs, one-on-ones with the mayor?
To this date, I have never been requested or have had a meeting directly with the mayor concerning the Department of Personnel, other than the Zoom call, the virtual meeting in which we had to discuss my position on the commission, and meetings where she would have guests that would come in from outside of the city, and it may relate somewhat to personnel, and she would ask me to be present for those meetings.
And so, a one-on-one meeting, I mean, were you and she, sorority sisters, having coffee, talking about how to improve the city's HR function?
No.
Nothing?
Nothing.
In 2.5 years?
In 2 years. Nothing.
You find that wonky?
Yes.
Why?
I find that wonky because the way in which we get the work done in the city for our taxpayers is through people. And so I see human resources as a key element of getting that work down, getting that work done. So for me, it would appear that a CEO, or in this case a mayor, would have their HR person right at their right-hand side, especially with the issues that the city was dealing with regards to HR, getting people hired, et cetera. And the other thing that was troubling for me is that being new to city government and never working for city government, in my depending on the mayor as well as my team to educate me and teach me, I would think that we would have had a meeting in there someplace where she just taught me or told me how the city operates and what she expects of me and those types of things. And those conversations never happened.
Or just have coffee with a sorority sister who happened to be the director of personnel, right?
Right, right.
And that never happened?
Never happened.
And you also talked to the city councilor?
Yes.
Right?
Yes.
Why'd you go to city councilor?
Because I wanted to understand what my legally what I could do or not do because of the circumstance that I felt myself in, where I literally felt that I was in a hostile work environment. Every day that I walked in, I didn't know what I was going to have to face.
So was there a time when you went to Sheena and the city councilor, Sheena Hamilton, was there a time you went to the city councilor and you made a request that the city pay you to engage independent counsel to represent you in this context?
We object. It calls for attorney-client privilege communications. It's irrelevant, again, to this situation. It has nothing to do with the charge that is pending against the director.
I didn't ask her what Sheena's response was. I asked her whether or not she went to her to make a request for independent counsel to be retained on her behalf, and there's nothing privileged about that request.
But not about this case. She's not going to testify that she asked for city council to give her counsel for this matter.
All right, and Mr. Harris, you're a little bit ahead of it. Mr. Norwood, are you going to contend here that this conversation that you're asking about between Ms. Gray and the city councilor has something to do with the charges against her here?
Absolutely.
How are you going to logically tie that up?
Oh, it's easy, Your Honor. Oh, let me. Right? We have moved.
I think that'll probably take us to 5 o'clock.
It
but
probably
go ahead.
will. It probably will. We filed a motion with the commission We filed a motion and a writ with Judge Moriarty, which was denied. We filed a writ that same day with the Court of Appeals, which
That was also denied, right?
It was denied. And in that motion.
And today you filed it with the Supreme Court, and it
they
was denied
that.
today.
They
right?
denied that. So everywhere up and down the line, they denied what we have raised, and from Judge Moriarty's standpoint, and I think perhaps she was spot on. She said, you have to exhaust remedies. Said, I had to come to you all and beg you all to disqualify.
I wish you hadn't focused on that word exhaust.
Well, I got plenty of that too.
But anyway.
But exhaustion. Yeah,
Go
but
ahead.
but yeah, I mean, we're between a rock and a hard place. We go over to across the street, or actually down the hall, and we say, we need relief because we got a problem. We got the lawyer for the city who investigated, assisted investigation of my client, also representing the commission that's deciding whether or not their investigation is a proper and satisfies the requirements of malfeasance. So they sent us back here, and I raised the issue. And if I could be misremembering because it's a long day, if I understand the ruling, is that we don't have authority. So exhaust your remedies. Well, we can't help you. So that means we got to go back to the court, and back to the Court of Appeals, and back to the Supreme Court, if that's what it takes, because we're entitled to an answer to this serious ethical question about how is this fair? To get back to my football analogy, that's like having a punter who's in the locker room with the other team, misses a punt or two, and then goes over to the other team and kicks it the winning field goal. That's exactly what we got here. That's what I'm confronted with. I didn't write this script, but I know how to read it. And so, yeah, it's connected. Because what happens is, she went and she said, I want Ron Norwood to represent me.
Now-
That's what she said. No,
now
let me
he's
finish.
testifying.
No, I mean, put me under oath.
Again,
Put me under oath.
none of this relates
Put
to
me
this
under oath.
case.
I'm connecting the dots.
None
If you'll
of it
let
relates
me,
to this
let me
case.
connect my dot. I mean, I'm in the middle. I got a good dot right here. Let me finish.
All right, the dots you're trying to connect are her complaint to the city councilor about
That's
a
one.
hostile work environment.
That's one.
And that she wants to hire a private attorney and have the city pay for it.
Have the city pay to protect her back.
Okay, how is that related to this case?
Because now, that same lawyer who represented her and told her, you don't need Ron Norwood, you got the city councilor backing your back 100%, and she called me, and I don't want to disclose any attorney-client privilege, but didn't happen. So, then, when the charges are filed, those same people who said they had her back, they got a knife in her back. Same lawyers.
I'll say again.
The objection is sustained.
Okay.
All right, and with that,
What's the objection?
the objection to your last question
It wasn't a
is
question, it was
sustained.
actually a
The
colloquy.
question about asking the witness about her conversations with the city councilor, about getting her legal representation, allowing her to hire private legal representation, doesn't say anything in, I don't think, in your motion about it being you, but regardless of who the attorney was, that's irrelevant to this proceeding.
Well, we supplemented our filing with, I think, a 100-page writ petition with a lot of law and a lot of facts. 'cause
That's
we didn't want
correct.
to burden
It's in
you
there,
with too
you
much paper.
supplemented it, but the ruling is that that's irrelevant. Now, it is, I've got 4:57. So that ends today, Mr.
Well,
Norwood.
can I?
You can think about what your next topics that you're going to want to ask Ms. Gray about when we come back, because she's still your witness on the stand. She was called by the city as their first witness. This is technically your cross-examination of her. You are in the middle of that. I was hoping you were at the end of it, but you said you had a lot more to ask about. We're going to have time now, Mr. Norwood. We're going to have to continue this hearing to a week from today,
Week from Monday.
I'm sorry, a week from yesterday.
Monday.
That's the 13th. What about it?
Well, let me look,
And Mr. Harris, are you looking also?
He's already told us he's available.
I'm available.
the 13th,
Yes, I believe that's next Monday.
okay. 13th, does that work for you?
I'm sorry.
And do we want to hold the day after that?
Hold the day after.
The 15th would be better. I already have doctor's appointments on the 13th.
The 13th is Monday? And, okay, and I have an important equity partner meeting on the 14th. And I have, well, I can reschedule that. And I leave on the 16th to DC at 7:05. So technically,
AM?
PM. So
PM.
technically, I can do, as long as we get out of here, I can do the 15th and the 16th.
I think we have a regularly scheduled civil service mission and meeting on the 16th. 15th and 16th,
Is it 15th, okay?
are they for you?
I believe so. Mr. Harris, did you say 15th and 16th were okay for you? I know you said the 13th was okay.
Yeah, I can do the 13th, I can do the 14th, I can do the 15th, I can do the 16th.
All right. And Mr. Norwood, you have a flight that leaves Lambert?
At 7 p.m. for DC to
So
visit
you'd
my
have
daughter.
to leave
yes.
here at what time?
I'm sorry?
You'd have to leave here at what time?
I'd have to leave here, let's see, with traffic, assuming no snow blizzard, I would say I would want to get out of here by 4.
Well, then, our goal will be to have our hearing completed, hopefully, no later than that.
Yes,
On the 16th.
And we'll continue the hearing, if that's by consent with everyone, to Wednesday morning, the 15th of January at 9 o'clock. Or, no, I'm sorry, we've talked about this, the commissioners have decided they would prefer to have the starting time be 10 o'clock. And so let's hope there's no blizzard. The
Yes.
16th?
yes,
15th and 16th, 9 o'clock both those days.
yes.
But everyone is
Well, 10 o'clock on the first day,
both 10 o'clock on the second day,
10 o'clock on
both days,
10 o'clock both days. Okay,
both days.
got it.
We'll start at 10, right?
Yes.
And the first day, we'll do the same as today. We'll go, if we haven't finished, by the end of that day, 5 o'clock, and then start the next day,
Yes, Your Honor.
okay?
That works for us.
That works
And
for
Ms.
us.
Gray, you said you're available then too? And the other witnesses, obviously, both of you are going to have to check and deal with those witnesses,
Yes,
all right?
yes.
And we'll take up any, if there are any problems, we'll just have to deal with them at that time, all right?
Thank you, Your Honor.
All right, and certainly appreciate everybody's patience here today. And for those of you just here as observers, I hope it was educational.